Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. I am enjoying this music. Afternoon. Oh, the music right now. Thank you for joining me. I'm Ada K. It's great to have you here with me today. We are doing a deep dive into a lot of documents. Now, I don't know if we're going to get through them all, but we're going to get through a lot of them. There's been a lot of documents that have dumped lately in the Karen Read trial, and so we are going to read them. And I'm going to be counting typing errors, and some of them are so horrendous. One sunny day. Oh, yeah. So we going to be having some fun with this because one of these documents has to have at least 25 typos in it. And so we're going to have fun. But I was watching another content creator, Laura, and I kind of took some notes. So I want to read some of my notes to you concerning the Karen Read trade. There has been some interesting information that I hadn't heard of that he talked about. So I was feverishly taking notes. Hello, it's Brit Haley Mouse. FBI public corruption. These documents dropped lately are wild. Yes, they are. And do you know how many of us watched boxing back in the day? Back in the day. And it was, let's get ready to rumble. Well, now let's get ready to document because these documents are just too much. They're just too much. But before we do that, we got to do yesterday's giveaway entry for the giveaway, which we'll do at the end of this live. So let me share screen. I got to be honest with you guys. I almost had a throwdown with some people in the parking lot earlier today. I kid you not, I almost had a real throwdown in the parking lot today. Let's see if I can get it over here. What am I looking for? So anyway, we had a massive entitled asshole. Anyway, drum roll. Let me know if you hear it. Did y'all hear the drum roll? Jesse was the winner entry for yesterday. Congratulations, you are in. But yeah, yesterday we had I was not having it today with this person, and it was pretty bad, and they parked all the way into my part of the parking lot. And I was a little bit miffed about it. Oh, that's not what I wanna share. Let me pull it up because they had a sense of entitlement that I just don't go for. There's what I want. Save. No, I don't want that. This thing is not cooperating with me. So anyway, I was one of those people who was just all like, "Come on, honeymoon, we're gonna have a throwdown." And so yeah, they had a beautiful brand new Lincoln Navigator, which used to be my dream car. And they parked at least 2.5 feet across the line. And so I had to pull in. It was only one parking spot, and one car parks this way, one kind of parks on an angle. And he didn't like how close I got to his car, so he came around and started giving me lip. And I'm like, "This is a Saturday. This bitch gonna throw down." And I did. So, yeah, I just let him know that entitlement doesn't get anywhere with me and that I will be happy to, accommodate him if he thinks his wife goes, "She's gonna scratch our car with a key. We got" and I'm all like, "All right, where do you want him? Where do you want the scratch, my dear? I'll happily give it." No, I wouldn't do that. I'm not that kind of gal, but man, welcome FBI public corruption. Welcome to our page. But yeah, no, we were gonna go down. We were gonna go down. I was not a happy woman. I don't like being someone just looking at me and thinking because I have a lesser value vehicle than they do, that they think I'm gonna destroy their car just because I tell them they're being assholes. So anyway, yeah, it is what it is. Okie dokie. So that's not what I wanted to share, but anyway, I'll come up here and we'll read that. And so I took some notes. It was something that I had some of the things I hadn't heard before. So let me give you some of my notes. So the defendant's motion, that despite the claims to the contrary, the defense never filed a motion to preserve or specifically require or request prior to November 2024. We're talking about the evidence, especially, i.e., the video cameras. And the defense has been saying, "Hey, we requested on such and such a date that all this evidence be preserved." And the prosecution saying, "We didn't receive a request until November 2024. We don't know what you're talking about of the surveillance videos from the Canton PD." So, in this matter, it would eventually rely on judicial discretion if determined that the board vague requests of the defense are specific enough to in the requested video. So basically, they're saying, "Yeah, well, the video may have been requested, but it was too vague. It wasn't specific." Oh, I know on Sunday they were like, "Wait, okay, so our parking lot." I'm gonna do this. I'll show you. This girl can show you. Hold on a minute. I'm gonna show you. I gotta plug it in first, y'all. I got to plug it in. Then I can show you when it pops up on my screen. Go live. Go live. Go live. Okay, camera number 2. All right, here's camera number 2, y'all. So you see this vehicle, that Toyota, that's my car, and I don't care. I have specialty plates. It's on an angle. The other car was parked to the right of my vehicle or to my left, right where that empty spot is, and it's kind of like 2 different angles. One pulls in straight, one pulls in on an angle, and you have that little yellow stripe line there. Well, they were parked all the way into the middle of that line at the top, but at the bottom, because it's a wedge shape, they were actually in this parking spot. So I had to pull in and invade a little bit into the spot next to me. But anyway, they got their knickers in a knot and they were not happy with me. And I'm all like, "You're in the wrong, dude." And so they went and I'll show you over here. Oh, wrong one. Wrong one. Which one is it? There. Do you see way across the street? You can see that building across the street. That's where the car wreck was. They parked in their parking lot clear across the street because they were afraid I was going to key their car because I'm not dripping in freaking money. She had a Louis Vuitton purse, probably fake. And she was being a bitch. What can I say? If you're going to be park within the lines, I never ding people's cars. I'm very careful about it. I try to be as respectful as I can of everybody's vehicles because I want them respectful of mine, although I've had a lot of people ding my car. I mean, my car's all beat up. So anyway, let's go back to this. So we're sitting here and they're basically saying, Your Honor.
Your Honor, the request to preserve the video evidence in 2022, 4 days after the red rum, was too vague.
I'm like, bitch, please. So the matters were so in other words, they're unaware of this video. Okay. Then they say judicial discretion is going to have to determine this because it was broad and vague in the request. Was not specific enough from the defense. I'm like, come on, any and all evidence, including video. That's not vague. Any and all is very specific. So the prosecutors were unaware of this video existence in Sallyport. They're saying,
but we didn't know that video evidence was even there.
I'm like, come on now. None of you knew. Yeah, I'm a goody two shoes. I don't want to get in trouble either. The prosecutors were unaware that the video existed at the Sallyport. If the prosecutors who worked with the law enforcement did not know about the video, it is unreasonable to expect the defense to be aware of it too. I got to do it.
But, Your Honor, is it not reasonable to assume that there is video recording in the Sallyport, especially based on other cases that they have presented video evidence from that very same Sallyport? So, are you telling us that the video recording devices in the Sallyport are used selectively? So, in another case, you record it, and in this case, you choose not to? Are we being selective assholes?
Yes, I'm in a mood. I know. I'm probably not going to get monetized. Oh, well. So you see my point. Is it selective? Like selective hearing? You use it when you want to? It's very evident that, I mean, it actually seems to be, it's a reasonable assumption that a police department that has video security surveillance on the outside of the building would have it in the Sallyport. And you have had millions of other cases. I don't know how many thousands, hundreds, I don't know, of other cases. And you have had Sallyport videos in those cases. Why would we not assume? And of course, when you assume,
you make an ass out of you and me.
And that there would be video evidence. So that
shit don't fly.
Yep. That don't fly with me. So now the trial prosecutors were not informed of the surveillance video. This is what they're stating, that the prosecutors were not informed of the video surveillance in the Canton PD Department Sallyports until receiving the federal grand jury transcript of the Manassas State Trooper Michael Proctor. Where is my, I like having it. Michael Proctor, our favorite a-hole of the entire case. The lead case agent and investigator knew about this video, but did not inform the state prosecutors. I don't believe it. So the grand jury testimony revealed that Michael Proctor knew the video existed and informed the federal prosecution during the proceedings, but did not inform the state. I bet there was a happy
Sidebar.
in that hearing. The prosecution team acknowledged the prosecutor team's knowledge or lack thereof of the Sallyport videos came from Michael Proctor. Despite his testimony indicating the video existed, the defense has yet to receive full access to the footage on April 4th on April 4th of 2024. So just before the trial started, the eve of trial, the Commonwealth provided the defendant with the surveillance videos, including footage from the main driveway of the Canton PD. However, the question remains, why only clips were provided and who decided which parts to keep and which parts to cut? That's a good one right there. Who was the deciding factor in who got to keep what and what stayed in and what was tossed out? I find it interesting, and I'm not wondering if it's the retired PD detective who is putting together 2 reports and presenting the drive of evidence off of his own hard drive. Oh, but it is on his hard drive, or is it on the Canton PD drive? See, that's the thing. There is a very big inconsistency on where this information is. I'm in a mood, guys. It's Saturday. So if I'm cussing, I'm sorry. Not sorry. It's just one of those days. Woke up in a good mood. Entitled Rich Asses made it different for me. I'm still in a good mood. And do you know one thing I told somebody? I said, do you know what? Just because I choose not to spend $80,000 to $100,000 on a freaking vehicle, when I could spend $40,000 on the vehicle that gives me the same pleasure and the same meets all my needs, and that money can go elsewhere. Just because you have it doesn't mean you should blow it. And if you're stupid enough to blow it like that, and you're stupid enough to park over the line in a parking lot, you're gonna get something could happen to your vehicle. That's all on you, boo. I wouldn't do it though. I'd crawl all the way through and get out the other side. I would never purposely ding somebody's vehicle ever. So anyway, back to the story. April 17th, Brian Tully sent an email stating to Chief Referee reviewed the video of the surveillance arriving at PD, stating that he reviewed the video of the SUV arriving at CPD. Now, this contradicts the defense's claim. The video shows the vehicle entering the Sallyport and the crime scene tape being put up. The prosecutors were privy to this. The prosecutors were not privy to this video and weren't aware at the time. Now, after the trial, August 21st to 24, Canton PD provided the Commonwealth with 2 additional videos. One of the interior Sallyport camera on January 1st and another showing Brian Higgins, Canton PD, in the Sallyport during the early hours of January 29th. These videos depict activities consistent with witness testimonies and they rebut the defense's suggestion that the video had been tampered with. Further clarification will be needed on the timing and the method of how those videos were discovered and turned over. That is where we are right now. That is where we are right now on that issue. Now, we are going to try, and I'm going to give a recap. I will go ahead and put this up so y'all can see it too. It's not showing me what I want. Yes, it is. I hate that default that it goes to. Nothing I can do about it, guys. My apologies. But I am beginning this to the best of my ability. Ability. There we go. Okay, now I need to put this in front so I can read it. I want to thank everybody for joining me today. It is March 1st. We will be starting a new giveaway, but for today, any and all super chats will double your entries. Anything you do today, if you hit, I got to do the I liked. If you do the I liked, everything will be doubled and I will give it to you for today. Would love to end it really strong. Okay, we only have one. We only have one right now, y'all. Come on. Y'all need to put I liked. You need to like the video. We have how many likes so far on the video? If you like it, you might as well put I like and comment ILIKED in the comment because guess what? When you do that, you're entered into the drawing. I'm trying to get everything lined up so I can read. We have 5 likes and only 1 in the drawing. Come on, guys. Okay. We are now going to be going through the Karen Reed ruling on a motion heard on February the 18th. Now, most of this we all know, but I want to go over this because basically the defense lost everything except what they agreed to do in court. I'm not going to read every word. Defense motion to compel video surveillance, paper or 483, motion denied. The Commonwealth is to comply with Masses R Crim P 14B1G, effective March 1st, 2025, today, which provides a pertinent part of the prosecutor shall permit the defense to discover, inspect, and copy all photographs, videos, and audio recordings in possession in the prosecution team. After hearing on February 6th of 2025, the parties reached an agreement that the Commonwealth would have a member of the prosecution team copy any surveillance video in the detectives' files. Well, guess what? They don't have it yet. Still don't have it. And now they're saying it's going to take a couple of days longer because he's retired and they can't force him to go any faster. And I'm like, honey boo, a court order can make him do it now. My shares were kind of wumpy. I don't agree with that. So would have a member of prosecution to defend files and materials on a hard drive and then produce a copy to the defense. The prosecution would be video recorded. They're going to record the prosecution doing this process to make sure they don't do anything wrong. There is no affidavit of an expert or any evidence before the court that the procedure agreed by the skilled counsel for both parties would result in a destruction of metadata. Process agreed by the parties satisfied the Rule 14B1G and complies with the court order of October 5th of 23. Court order October 5th of 2023, y'all. That's a little bit long. Thank you, Kathy L. Everybody, thank you for joining. Motion for admission pro Havax. I can't say that. Prohakvis of Mark Borlow. The affidavit in counsel is insufficient. Attorney Yeti will provide additional affidavit. Motion denied or under advisement. Sometimes I want to know what this judge wants because I saw the affidavit. I don't understand what the problem is. The Commonwealth has agreed on the defendant's motion to compel discovery. Paper 495. Allowed in part, denied in part. Defense request 1. The Commonwealth has agreed that the court ordered production of investigative materials sought in the possession, custody, control of the prosecution team. The Commonwealth has an ongoing obligation to provide items, information favorable to the defense. There is no requirement under Rule 14, the Commonwealth, to create items that do not currently exist. So there is the denied in part. I'm like, are you kidding me? Thank you, Haley Mouse. Are you kidding me? So you're saying that the defense is expecting the prosecution to create documents to assist in their defense? I think, Auntie Bev, you need some new reading glasses. That's not what I got from the motion. Defense requests 2, 3, and 4, denied without prejudice. The court does not have enough information to determine whether the request is beyond the scope of the Commonwealth's obligation under Rule 14, or whether the request of discovery is material or relevant. The court also understands that the material sought by may be protected by federal protective order. Counsel is free to file a supplemental memoranda or provide the court with a redacted version of both parties having their possession, provided doing so not in violation of protective order by the feds. Yep. Number 5, this quest discovery is outside the scope of Rule 14. Denied. Where's my gavel? Denied. Then we have defense request number 8 and 9. Denied. Oh, sorry about that. In part, as overbroad. The Commonwealth must provide a discovery consent with their obligation under Rule 14A, 14B, 14.2, and Rule 14.2F. Defined of the work product does not include any item or information that the prosecutor is obligated to disclose as items or information favorable to the defense. What? Definition of the work product does not include any items or information that the prosecutor I got what they're taking. Their own personal notes and whatnot. The court is satisfied in the written response of the Commonwealth indicates that the Commonwealth understanding of the discovery obligations as outlined in the rule and the reported notes to the rule and of its continuing duty. Happy Saturday to us. Beverly Canoni, you suck. I'm sorry. I really need to keep my mouth under control. But it's hard, said the Buddy Cat. Yes, you were seeing me in rare form today. I am the I don't give a shite mood today when it comes to this hearing. Hopefully I'm sharing the right window. Let me get this up and see. Defense. Yeah, I think that's the same one. Okay, guys, I struggle like crazy with this document because this is really tiny. I wish I could make it bigger. I wish I could make it bigger, but the lettering is so small. Let's see what happens when oh, wrong page. Don't mean to do that. This page. It's a little better. Okay, that's better for me. Hopefully that's better for you. Did that work for you? Great. It just is going to make this a little longer to read. Okay, now we have the Commonwealth of Massachusetts plaintiff versus Karen Reed defendant. Defendant Karen Reed's motion to for the extraordinary governmental whatever. So I don't know what happened here, but that's mistakes number. I'm going to keep a tally, by the way, guys. I got to get to the tally. We got 2 mistakes already. Oh my gosh. Where did I put the pencil? The pencil. There it is. I need this to reach my little thing. We're going to count the number of typos in this document. Now, I'll tell you this. I will give you 10 additional entries to the person closest to the numbers of mistakes that we find in this document. Hopefully I find them all. Paralegal probably sucks. He should have reread it. Okay, now comes the defendant, Karen Reed. Miss Reed respectfully moves. I'm not going to say the honorable. The courts, pursuant to Article 12 of Manassas Declaration of Rights and the 5th and 6th and 14th Amendment of the United States Constitution. Construction. That's a mistake. And Mass R Criminal of 14 dismiss all charges with prejudice on basis of extraordinary governmental misconduct. Oh my gosh, don't you know that they're just going to love that word? And we're not going to read the sites. A prosecutor might strike down and blow, but he may not is that right, y'all? Is that a word? Y'all. Is that a word? It's a mistake. It's a typo. It should be a beauty. Okay, strike raw ones. That's another one. Rule 1. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is every legitimate means to bring about a just one. Once again, that's a mistake. Guys, just in 2 paragraphs in a title, we have 7 mistakes. Are you kidding me? Throughout the course of these proceedings, Miss Reed has severely prejudged by the Commonwealth's pervasive misconduct. I'm going to get tired of hitting this button. I'm going to tell you. The Commonwealth has suppressed discoverable exculpatory video surveillance footage from the Canton PD, CPD. It has provided piecemeal disclosure of some footage, most of which was disclosed after the trial started, and the Commonwealth represented that all video footage has been produced to the defense. For reasons that remain unexplained, much of the video has been disclosed, as is missing crucial time frame evidence and central to Ms. Reed's defense. Some of the evidence clearly appears altered, manipulated, and as evidenced by the people appearing and disappearing out of nowhere. At the first trial in this matter, Assistant District Attorney Adam Lally, Ada, hi, that's me, don't wear it out, Lally, brazenly introduced inverted video and elicited plenty of false testimony from the MSP Sergeant Yuri Brutnik that the video was fair and accurate depiction of crucial events in an attempt to falsely insinuate to the jury that no member of the law enforcement had approached, touched, or otherwise disturbed the right rear taillight of Mrs. Reed's SUV. There can be no doubt that this video and false testimony was offered to mislead the court, the jury, and the defense by making it appear that the MSP trooper, Michael Proctor, was standing next to the left rear taillight when the Commonwealth knew exact opposite was true. Trooper Proctor was in fact standing directly nigh the taillight, right rear taillight. Other Sallyport video, which is unquestionably favorable to the defense because it would have severely discredited the key witnesses, Brian Higgins. Yeah. Okay, y'all. All right, I want to talk about this for a second. And right now we are up to 10 mistakes and we haven't even gotten through half of the first page. Oh, y'all. Okay. As I said yesterday, and I'll say it here today because it's probably going to be a little cleaner. And I gave it Exhibit E, and I'll do it again for those who were not here and did not know and were not able to see. I don't want to leave this live, so don't do that to me. We're going to remove this. We're going to embiggen me again. And I'm going to hold up my fabulous lotion. This is properly recorded. You can read that it says Gingham Fresh by Bath & Body Works. No, I am not sponsored. However, if I'm trying to get the mic out of the way as much as I can. There we go. If I go in my settings and I say mirror, and I'm going to mirror this. Now it is backwards. It looks like it is on my right side of my body. But when I go back in and I take the mirroring off, it is on the left side of my body. And you can read the words correctly. Here's where the problem was. The video itself was mirrored like this, but the words and the timestamps were readable. That is a major altercation of that video. Major altercation of the video, in my humble opinion. because there is no way on God's green earth. I'm going to go ahead and move me up since it's just me. There's no way on God's green earth that this video here at all was an accidental inversion based on the fact, sorry, I'm trying to get this where it clips just right. There we go. Based on the fact that if the entire video was accidentally transposed, so like when you put it in PowerPoint and you can pop it in, and sometimes your sizing, you drag and click, you can flip the video real easily. If that was the case, then what would have happened was all of the timestamps and everything would have been inverted. Just like I showed you right there, the words would have been inverted. What was left is now right, and the words are now, what was readable is now backwards. That is not what happened in this case. In fact, the case was the timestamp and everything on the bottom of the screen was still perfect. You could read it. It was perfect, right direction, but the camera video itself was backwards. That meant it was sliced and diced and re-put back together, and that is tampering with evidence, and that should be a freaking mistrial, in my humble opinion. And IMHO makes me a hoe, and that's exactly what I am. I'm a court hoe, and y'all got me in a weird mood today. So anything with that, I'm going to go back. We're going to keep reading. There's a lot of pages to this, guys. So some of the video clearly appears altered and manipulated, and the evidence, did I read all that? Yes, I did. It's down here. Something was redacted explicitly, not disclosed to the defense until months after the first order instructing the defense to disclose it. I don't know. I'm going to take that out. Not disclosed to the defense until months after the first trial. Another misprint of this day, Commonwealth failure to something, the disturbing circumstances surrounding their disclosure of exculpatory Sallyport videos, and why some videos were suppressed from the defense at the first trial has made a mockery of misread rights and due process. Your spelling is making a mockery. Once they managed to invert it, they produced it in an attempt to say the car wasn't tampered with by police. I got to put it up, guys. I got to put it up because it is getting so deep in here. Here's the bullshit meter right there. Hello, Gabby. Welcome. The Commonwealth exploited two misspellings there. Impeachment material in advance of the witness testifying. Ada Lally, Ada, my name. What can I say? ADA Lally and MSP Lieutenant Brian Tully. Lieutenant Tully. Hello, everybody. Huddled with key witness Jennifer McCabe.
Jen! Hey, Jen! Hello! Wake up! Miss Jen!
I have to do that. Every time I hear her, I see that Jen exhibit she did in court. That's all I hear from her. And I want to tell her.
Bitch, please.
So anyway, Jennifer McCabe, mid-trial. So they had a huddle mid-trial and prepped her on how to explain why she never disclosed. She went to Canton PD Sergeant Michael Lanks' home one day after John O'Keefe's death, and then suppressed exculpatory statement, made by McCabe during the session until nearly a month after Jennifer McCabe's testimony. At which point, McCabe and other relevant witnesses were safely off the witness stand. If the Commonwealth had complied with their obligation to provide a statement of witnesses before they testified, defense would have had a position to expose Miss material inconsistent statement about her meeting with Sergeant Lang. This is all redacted here. That's why that's there. Thank you as the gavel drops. By the way, if you're hitting a mod, drop as the gavel drops in the comments, please. As a result of this extraordinary governmental misconduct, Miss Reed has permanently and irrelevantly denied the constitutional right to a fair trial. No remedy other than dismissal can adequately address the significant harm caused to Miss Reed and the injustice of the proceedings without loss of exculpatory evidence that the Commonwealth possession. Accordingly to the case of Miss Reed must be dismissed with prejudice. Yep. We're going to go down the statement of facts. And we're going to have fun with all the stuff. Miss Reed is accused of the following crimes arising out of the depth of Officer O'Keefe murder in the second degree violation, manslaughter while under the influence of alcohol violation, and leaving the scene of personal injury and or death. Thank you very much, Haley Mouse. A months-long jury trial was held this Mavic beginning in April 17th of June and on June 25, 24, the jury began deliberations. After the jury submitted a note to the court indicating the jury was at an impasse, the court declared a mistrial on July 1st, 2024. July 1st of 2024, a mistrial was declared. Hopefully I pinned it. Yeah. The Commonwealth, and here's a typo. The Commonwealth altered the course of the first trial in this case, destroying exculpatory evidence, withholding exculpatory evidence, and whatever, interfering or something, the jury. In the case in which the jury either voted Zoe acquit or was deadlocked on the lesser's one charge, no blank short of dismissal prejudice can remedy seriously constitutional statutory. And in the days and the weeks following the first trial, 5 deliberating jurors have come forward and indicated that they had unanimously acquitted Ms. Reed on 1 and 3 only with the respect of count 2. That is not clear writing, my dear. They have indicated that they did not believe that they were reported unanimous decisions on count 1 and 3 unless they were able to reach unanimous verdict on all counts. This is the discrepancy right here. Let's talk about this. They, the jury, indicated or believed that they did not believe they were to report the unanimous decisions on counts 1 and 3 unless they were able to reach a unanimous verdict on all. That is a procedural cluster. That's a procedural cluster bleep because it was not clearly written, and I have argued that from day one. Whether you were for or against Miss Reed, whether you believe she's guilty or innocent, when you look at the jury's instructions, this here is why they did not fill out number 1 and number 2 and 1 and 3 is not guilty and report it. This was their problem. Miss Reed's failure to address any claims of double jeopardy in the instant motion dismissal shall not in any way be deemed or to construe a waiver of those issues, which are presently pending before the United States District Court of Districts of Massachusetts. Oh, well, we already know the result of that, but we're going to keep reading. The violations set forth below. I'm just reading at this point, I guess, in some ways to figure out how many typing errors there are. The court is aware of the critical importance of the video surveillance. I got to move this footage from CPD. They should have put Canton PD. January 29th of 22, the Commonwealth has produced dribs and drabs. I love this. Dribs and drabs of video. Oh my God, I could go so bad with that. With the Simitill trial. Dribs and drabs of various clips of video surveillance obtained by CPD. That's a typo. Version DVR without any complying records, evidence, logs, or other documents regarding the recovery chain of custody evidence on at least 4 separate occasions. Okay. I was thinking about, well, there were some dribs and drabs in that toothpaste tube. Yeah, I know. I said it. I said it. You were thinking it. T-Gas, welcome. Relevant discovery orders. The relevant discovery orders on February the 2nd, 2022, the defense filed. Defendants, see, they messed that up. Emergency motion to preserve the evidence, including preservation of all physical, such as video surveillance footage with the Sutton Police Department Exhibit A, order motion preserved. Hi, future. So you catch me in a very rare mood, love. Mood. So remember when we started, I talked about how the Commonwealth was saying that it was not clear, that the defense did not file a clear request to preserve the videos. What the hell do you call this? February 2nd, just days after the unaliving of O'Keefe, the defense filed an emergency motion to preserve evidence, including the preservation of all physical evidence, such as video surveillance footage, with the Sutton District Court, and it was preserved. Hello. And ADA Lally required to notify law of something evidence on February 22nd hearing. Ada Lally stated in open, that's another typo, court that he had reviewed the proposed order and had no objection to it. So Lally is going to be thrown under the bus on this one. That same day, the district court issued a preservation order for all physical evidence. Bum-ba-ram, all. Do we know what the word all means? Let's go back to kindergarten, shall we? Including video surveillance footage, another typo. In other words, 3 days after another O'Keefe's death, the Commonwealth was aware of its affirmative obligation to preserve any and all video surveillance footage in its possession and custody or control, which included CPD, Massachusetts, whatever the enforcement in the order. Hello, Jesse. Now we roll forward a little bit. September 16th of 2022, after Miss who? Typo. Miss Reed, following her June 9th, 22 indictment, the defense filed a separate motion to compel the production of certain outstanding discovery. Okay, so we had a discovery. I got to go grab that door. Everybody take a quick restroom break. I will return to you. Enjoy the funk. Okay, sorry about that, guys. This is a Saturday, and I always try to give my son some time off. So I will be getting the door for him. He's such a good son. He really is. He's such a good guy. It's the least I can do when I commandeer his rooms for a podcast. I mean, come on now. You know, when you commandeer something, you got to pay somehow. So, anyway, so this whole thing here is driving me batshit crazy because you're sitting here telling us in statements, oh, but we didn't know it wasn't filed until 2024. I just read that to you. Now we're seeing it was filed just 3 days after the unaliving of John O'Keefe, the request for all this information. So, following the June 9th, the defense separate motion compelled the prosecution certain outstanding discovery. We read that. The court granted the motion to compel in part and ordered the Commonwealth to produce all, October 5th of 2025, 2022, all. So to compel them in part and order that they produce all evidence, all. Do we need to go back to school and figure out what the word all means, prosecution? Hello, all means every single part, metadata included. The date of production and facts relating to the discovery and consensual violations. The CPD video surveillance footage has been in the Commonwealth's possession, custody, and control since January 29 and 22. And of course, we have freaking redactions. But here's the thing. This to me is huge. If I'm on a witness stand and I hear that, and then I hear that they still haven't gotten everything, honey boo, we gonna have a problem. Notwithstanding, the court, oh my God, this typo is killing me. Courts October 2022 compelling the production of all evidence and accompanying metadata in the Commonwealth's possession. The Commonwealth and its agents withheld this exculpatory evidence from the defense for more than 2 years, failing to disclose even the first incomplete batch of footage until the eve of the first trial, April 4, 24. Why are they getting sanctioned? Why aren't they getting in trouble? Why are they permitted to behave this way? If the roles were reversed, there'd be contempt of court left and right. What the hell? The Commonwealth has now produced 4 separate incomplete batches of video surveillance footage at the CPD on January 29th of 2022. April 4th of 2024 production. On April 4th, 2024, on the eve of the first trial in this matter, the Commonwealth for the first time disclosed hopefully incomplete CPD video footage, which consists of video from the CPD main driveway and the CPD Sallyport front wall. The camera from January 29th of 2022. See notation. Courtesy of the Sallyport front wall footage omitted 42-minute interval at the precise time that the SUV arrived in the Sallyport garage. That is no coincidence. Yes and no, but when you look at the original doc, all these typos are there too. There's a lot of typos there. This one, not so much as the other one that says for the, it's all run together. But anyway, I'm having fun with it. It's possible. But once again, it's omitted 42 minutes at the precise time that the SUV enters the Sallyport. If you want to make this look like it's a drop in the video, because here's what they're saying. They're saying that the video is motion censored, which means that there has to be so much motion before it starts recording. Honey boo, let me say this. All my cameras are motion censored except for this one. And it takes that much of a movement for the camera to think it's something's happening, and then about that much for it to start recording. And the thing is, turning on a light in the room automatically gets a camera on. I don't understand this. 48 minutes is not 42 minutes is not, oops, the camera didn't realize something moved and thus it didn't record the motion. Bull crap. If you have a little mouse or a cat or something small running in a big room, the camera may not pick it up, but I have to say the cameras nowadays, come on, even the cheapest Ring will pick up my cat walking across the sidewalk in front of the house and catch it within seconds of it entering in the frame. So I am calling bullshit on this. I'm calling it because there is no reason, rhyme, or anything for them to say that this particular thing did not get caught because it's a motion sensor and the motion sensor was not sensitive enough to. I call lie. I call fair ball. Nope, that didn't happen. I don't believe it. The missing footage is from the Sallyport wall camera would have captured a close-up of the condition of the SUV right rear taillight upon arrival at the CPD Sallyport, and B, the individual who had access to the rear taillight, and whether anyone removed the taillight material from the SUV. The first piece of the taillight evidence was recovered on 34 Fairview Road. Now that is a very big thing. You have to be like slow-mo on crack, man. This is the other thing. Because they inverted it, when they inverted the video, or the video was inverted, I'm not going to say they did it, the video was inverted. You can see Trooper Proctor and other people walking around to what appears to be the left tail light when it's actually the right. You can see them bending. You can see them looking at it. I wish I knew what day that video was played. I'd go pull it. Can anybody figure out, can one of my mods help me out here? Can anybody try to find the video of the Sallyport, the inverted video of the Sallyport, please? I will play it if you can find it. I just can't do all this and do that. The rear tail light of the Lexus SUV at the time it entered the enforcement's custody is perhaps the most critical and highly contested issue in this case, and it is. Do we know that it got knocked and it got a chip in it? It got cracked? Yes, we do. And that's even argued, but it was. It was astonishing. Chat. This sentimental time frame. Okay, should we check this? Our time frame is missing from the Sallyport from the wall camera footage. Moreover, the data was not preserved in a forensically sound way in violation of the February 2022 preservation order, which means that the defense has been denied the ability to determine whether or not the Commonwealth had deleted, altered, manipulated, or otherwise lost crucial video evidence in its possession that it was obligated to preserve. Yep. B, April 10th, 2024. The Commonwealth filed a certificate of compliance on April 10th of 2024, in which ADA Lawley certified to this court 6 days before trial. Certified to the court. I swear under oath to the court of the Commonwealth, after exercising reasonable inquiry, the due diligence to the best of our ability to disclose and made available all items subject to discovery. My thing is bothering me. So I'm like, okay, so now you go in court days before trial and swear under oath, Mr. Lawley, that you have turned over all knowing and unknowing everything that you have, basically, in this case. Karen Reed trial day 26. Oh, can you pop the link in here for me, please, babe? Because I've got every window so y'all understand. every screen and monitor is taken up with all these notes. So if you can do me a favor and just post the link to my thing in the comments, I can pull it up and we'll watch that part of the video. April, and if you can't do it, just say so. I appreciate it so much. Where was I? It strains critically it strains whatever credibility the ADA Lally in the light of his actual knowledge about the preservation order and the existence and extensive Sallyport video would represent to the court and to the defense that after reasonable inquiry, he disclosed and made available all known discoverable materials in his possession, custody, and control. At a minimum, rather than misleading the court and defense, ADA Lally was obligated to inform the court and the defense that there was outstanding video surveillance footage, and he did not do so. Let's see. You freaking rock. You rock, you rock, you rock, you rock, you rock. And that was at what time? 6 hours, 5 minutes? I'm pulling it up. Oh my gosh, y'all. Okay, I need to do something here. Here's that. Here's this. Share screen. I got to pop this out. I will pop it out and pop it back on. Give me a minute. Okay, we'll go in big end. Here we go. I don't know why there's no sound. It's no sound on their part. This is in reverse, y'all. And I can't get rid of that warning. But underneath, you can tell the time is correct. Look at the people. This is the right rear tail light over here. This is in reverse, y'all. This person in the white is Trooper Michael Proctor. They're over there. He's bending over. Look, he's bending over. Somebody else appears. You rock, Future. Love you, girlfriend. And see how the snow on this vehicle, it's in the rims. They are scraping evidence out the door. They should have cleaned the Sallyport prior to bringing the vehicle in, not after. And on top of that, how is that little piece of hair supposed to stick on it with all of that moving around going on? You were awesome. Thank you so much. I'm just saying. And look at all those people. Now you have 1, 2, 3, 4, 5. There's 6 people in this video, all up against this car. Nobody in any PPE gear. There is no tape around this car. Look how close this person is to the back side of this car. This is Trooper Proctor right here. What the hell? Anything that falls off the car, any of that snow could have evidence in it. They're just whipping it outside. Rutnick is on the stand for this. Thank you very much. We're going to go into this in a minute.
Executed on that vehicle.
Why do I not have sound on this?
We're establishing a perimeter around the vehicle
Sorry, we're going to
with
go back.
yellow.
We're going to go back and watch it.
Mr. O'Keefe's
my video
clothing,
was
which
good on
was
that.
already in.
Reference.
I'm sorry, I didn't realize it was muted. Let's go back to here. I'm going to watch it again.
Which was 5:35:36.
Look,
Okay.
everything is, the timestamp is correct. See, if you look at the bottom, 1/29/2022 in perfect order. Look, in perfect order. They're driving. Look at all the snow and the stuff around the vehicle. That should have been cleared prior to them entering.
And Sergeant, as far as the condition of the vehicle as you observe it in this sort of pause still shot of the video.
So, but if you're paying attention, this is the driver's side. They're going to get out. This is what would have caught my attention right there. Once again, look at the date, time, and stamp here at the bottom. It is 28, 29. I can't tell. But it says 2023. You can read it. But the video is in reverse. It's flipped because they actually drove it in this way. They entered the right side of your screen and exit the left. But that's not what's going on in the video.
Is that fair and accurate portrayal of the condition as far as the snow or ice or anything you observe on that vehicle when it came into the Sally Port garage?
Yes, it is.
Just gonna move through the site from there.
See, this looks like the right tail light, but it isn't. It's the left tail light. Now, look at the video.
You could just pause there for a moment.
He almost fell.
Sergeant's almost falling in the video.
All right, so keep your voice up.
Sergeant Buchanan, with reference to any individuals you see in this video, do you recognize any of those individuals?
I can recognize Trooper Proctor myself. Other than that, I don't remember exactly who else was present at this moment in time.
If you could start using the laser pointer before you just direct your attention to where you observe yourself and where you observe.
That's Trooper Proctor. and
Hello,
myself.
Chris.
At any point in time when you were present with this vehicle in the Sally Port garage this evening of January 29, 2022, did either yourself or did you observe Proctor touch or manipulate in any way the right rear passenger side area of that?
No, we did not.
Ms. Gilman, if you could play from here.
Okay, so the tow truck driver is the one that drove it in. He's the one taking a picture of the license plate. But the problem is he's supposed to take pictures all the way around that vehicle when he drops it off. He's supposed to do that when he drops it off, and he did not do that. See, he walked away. He did not take a picture of the rear license plate or the other three sides of the vehicle. And that is, I don't know if it's law, but I do know it is policy and procedure in a lot of places. Now, they're coming in and sweeping the snow out of the Sally Port. That should have been done prior to moving the vehicle into place. And they're slipping and sliding, probably bumping into the vehicle at some point. I don't know. I'm just being facetious on that. But look at him. Whoa! It's slippery. Yeah, no nut. Look back over here. That's Trooper Proctor in the baseball cap. You now have 3 people at the rear of the vehicle, 2 in the front. You can barely see that. Now you have 4 people at the rear of the vehicle and 2 in front. Now you got 5. What are these 2 little heads here doing and the third doing? That's the taillight area. Why are all of them huddled around that taillight? What are they doing? Yeah, and they're scooping away all that snow. Well, guess what? Anything that's dropping off of that vehicle is evidence. They should have had that Sally Port cleaned out before. Now you got 5 or 6 people at the rear of this vehicle. Look how close they are to the rear of that vehicle. This is not how you handle evidence in a Sally Port. I showed it to a friend of mine who, as a retired evidence officer, investigator. I mean, she was in it for a long time. And she said, this is so inappropriately done. Anybody within any of that distance of that vehicle needs to be in PPE, your personal protection equipment. Usually you're in like a gown or some kind of has a suit or something that's all white, CSI suit, as I call it, gloves, booties. Proctor is moving the dolly out of the way. Now somebody comes in and enters, goes back out. And what is all this commotion around this vehicle when this vehicle is evidence? They will eventually start putting tape up around it, but boo-hoo, it doesn't do a damn thing. He moved the dolly so he can wrap the tape around it. That's Proctor right there. Look how close they're standing to that vehicle without any protection gear on. So they're shutting the doors. Now they're pulling. And that's old tape. Look at it. That tape isn't even new. That tape is a wad of mess on the ground. It's not even a fresh new roll. You're not even supposed to use old tape.
Or what you recall from this, what is it that you and Proctor and some of the other officers are doing now?
We're establishing a perimeter around the vehicle with yellow tape in order to prevent or alert and advise anyone in the area to stay away from the vehicle.
Please, are you kidding me? Everybody's already been around the vehicle, too close. In fact, it looked like y'all were playing with the vehicle over here when you had 5 of you over there. That is not how, look how you go across. Where's the 4th corner? What are you going to put in the 4th corner? You're kidding me. You're freaking kidding me. You're crossing over the hood. It is not even all the way around. And you're putting that so close. They didn't even properly, where's the 4th corner? You just draped it over the hood of the car. I know. He must be, his neck is so tired.
Now, Sergeant Mechanic, are you aware of a warrant that was executed on that vehicle on February 1st of 2022?
I am aware.
And you yourself were not present for that, is that correct?
I was not present for the execution, no, sir.
Trooper Proctor was, as far as you're aware, is that correct?
That's correct.
Now, the next time that you were within the Canton Police Department Sallyport garage with the vehicle was on February 2nd, is that correct?
That's correct.
And on that day, where did the vehicle go from the police station?
From the Canton Police Station, I escorted the vehicle to the Milton Barracks for safekeeping.
And why was it taken from the Canton Police Station on February 2nd to the Milton Police Barracks? What had occurred in the intervening part between January 29th and February 2nd?
The Canton Police Department had recused themselves from interviews and in that portion of the investigation. And now that the vehicle had been processed, we needed to free up the Canton Sallyport so they can utilize that facility for transporting prisoners to their facility and booking. So we stored the now processed vehicle back at the Milton Barracks in a unheated garage.
And Your Honor, if with the court's permission, if I could publish just a very brief portion of what's been marked as Exhibit 34,
Okay.
which is the Canton Police Department Sallyport garage camera.
Okay.
And Ms. Gilman, what you have up there, I'm sorry, February 2nd, 2022, approximately 8:09.
February 2nd, 2022.
That through till about 8:10:26.
So now they're in where it is such poor quality. So it sat there for days before they transported it.
Sergeant, just for orientation purposes, again, this is another camera from within the same Sallyport garage, is that correct?
That's correct. That's the opposite view from what we just viewed in the previous video.
And as far as any of the people in this video, do you recognize any of the individuals in there?
I believe that's myself and then another officer. I don't know who that other officer is.
And just again, using the laser pointer, if you could, direct your attention to where you see yourself. And as far as the condition of the vehicle from January 29th, when you saw it on that day, to February 2nd, when you saw it on that day. As far as the exterior of the vehicle, what if anything was different, or what if anything you note or observe?
I noted the taillight removed and the evidence collected.
As far as
So they already
smell of paint on
processed
ice
the
that you
vehicle.
observed on that prior day, was that still present on Thursday?
Yep.
No, that had melted away.
Right.
And I was filming if you could again, I'm sorry, just wait through the 8:10:26.
So we're going to zoom past this until we get back to here. I want to hear.
Not a lead investigator, because the case officer organizes the individuals to assign different tasks and collect and organize the data that comes back from the third-party providers and from the interviews that are conducted.
As far as the interviews that are conducted through the course of this or any other investigation, is there ever an interview that's conducted just by one trooper or one person in any investigation that you've done with this unit?
It is, no. We conduct interviews with two people, whether it's a trooper and a local detective, or two troopers assigned to our office, other state police agent unit within the agency.
Now, as far as the case officer, who was the case officer on this particular investigation?
The case officer in this investigation was Trooper Michael Proctor.
And Trooper Proctor works under your supervision, is that correct?
That's correct.
So as far as a search warrant for the
So
ring video
it's your
from
fault
One
that he's
Meadows
a
Avenue,
failure, right? You're taking
was that
responsibility
done
for his
within the
bullshit.
search?
Trooper Proctor was the affiant.
And as far as from that search warrant, are you aware of the materials that were provided by Ring in response to that search warrant?
I'm
Okay.
going to allow.
Let's go back to the video and see what they pull up.
And Sergeant, have you reviewed this? And when time-wise, in relation to January 29th?
Oh yeah, this is what I wanted y'all to see. Watch the car move. Watch the tires wiggle. Boom, there it is.
Pause there for a second. Now, as far as the operator of that
There it
vehicle, are you able
is.
to observe who that operator is within that vehicle?
I observed the vehicle being operated. I cannot identify who the individual is, and then from that shot right there.
From at any point in the shot of the video that you observed, were you able to recognize the operator?
Not from that shot, no.
Now, with respect to the timing of this video, what time in the morning is this video?
The timing of this video is approximately 5:07 a.m. when the defendant left the home through the garage via her vehicle.
And why did she leave the home? She's going to look for the boy that did not come home. Now I want y'all to look. See the white shining through right there? That is the broken tail light. This is not no white over here. And by the way, my mother has this vehicle. I'm very familiar with it.
Now, from this particular
Right
pause
there,
portion
broken
of the
tail
video, Sergeant, what, if anything, of significance do you observe
And-
within?
Oh, guys, is that potential broken tail light right there? Do you see that shadowy? She hit him right there. Do you see that shadowy? I don't know what that is. They could have picked it up
the
from there.
Still shot of this portion of the
That's a
video.
broken tail light.
The portion of this video in the still shot presented identifies a missing, damaged rear right taillight, exposing the white light coming from the right side of that taillight.
And if you could, using the laser pointer before
I'll
you
put
drop
you
the
back
first
into
sentence,
him.
what you're talking about as far as that area of the defense. Now, earlier in that video, did you observe defendant's vehicle coming close to or coming into contact with Mr. O'Keefe's vehicle.
Yes, I did.
And as far as Mr. O'Keefe's vehicle, at least from this video, what if any?
Enjoy dinner, Haley Mouse.
Mr. O'Keefe's vehicle?
No damage.
And as far as the ground area around where Mr. O'Keefe's vehicle is parked, specifically the
Yeah.
rear of that vehicle, what
No
if
law.
any
No evidence.
red pieces or anything you
No
observed on
name.
the ground around Mr. O'Keefe's vehicle?
Nothing was observed.
What's right there?
If you could press it.
The tire stops here. What's laying down there? You see the tire stop here, but there's a shadow of something laying right there. Tire stop, tire stop. I don't know. But my thing is that we've seen the inverted video. Look, right there, broken. Yep.
Mr. John O'Keefe.
Okay, we don't need to see all that. Okay, so let's get this back up and running. Keep hitting the wrong button. So we're going to keep reading. Just wanted you to see. There it is. Okay, so we've seen the video of the Sally Port. The guy gets out of the driver's side of the car, which is in reverse. If he got out and the vehicle would have pulled in from the right side of your screen going to the left, he would have gotten out on the driver's side, not the passenger side. So that is the evidence. We're going to move forward. Okay, now my iPad's in the way. I'm trying to charge it and see everything. On April 23rd, 2024, the Commonwealth produced additional footage of the CPD Sallyport back wall via the share link entitled Additional Sallyport Video Download Link. Footnote 2. No drive was presented to the defense. Exhibit 8's inverted Sallyport video. We just saw that. The Commonwealth subsequently employed a mid-trial disclosure of the video surveillance footage as a part of an attempt to convince the jury, that nobody approached or touched the right rear of the taillight of Mrs. Reed's vehicle after it entered the Sallyport. Well, that's wrong because I counted 5 people at one time around it. ADA Lally elicits testimony from whatever that this interior Sallyport camera was an accurate depiction of the Sallyport and the SUV that it moved on this, moved when it moved at the CPD on January 29th, and that as seen in the video, no law enforcement officer approached the right rear taillight. Bull crap. There were 5 of you there. Lie, 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 you lie. You freaking lie, you lie. Yeah, I'm at the point right now.
All right, let's just admit it. That didn't happen.
The cross-examination, however, Sergeant Muchner testified, was exposed as profoundly misleading at best and prejudiced and perjurious at worst, plagiarist at worst. It became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image, critical facts which neither ADA Lally nor Sergeant Burknick saw fit to inform the court, defense, or jury, blah, blah, blah. In other words, the video made the left side of Miss Reed's SUV to be the right, and the right to appear to be the left, mirroring. Therefore, the video presented to the jury as a fair and accurate appeared to show a person, Trooper Proctor, standing near the left rear tail light of the vehicle, when in fact, Trooper Parker was standing near the right rear tail light, i.e. the tail light with issue. Yeah, we already saw that. We saw it. Moreover, the inverted video does not capture the condition of the right rear tail light, as it conceals Trooper Proctor's presence by the right rear tail light and leads to the inscrutable conclusion that the ADA Lally's question, Sergeant Burknick responses, and the deliberate introduction of an inaccurate evidence was designed to perpetrate a fraud to the court and to the jury and Ms. Reed with respect to critical issues in this case. I actually believe that. I actually believe. Now, I'm not going to, I mean, I personally don't believe she did it, but at the time that I was viewing this, I believe that she possibly could have done it. Because I didn't know anything. I didn't know anything about this trial. So when I came into this trial, it was like a juror. I didn't know anything. Post trial, October 10th of 2024, the Commonwealth again provided new footage at this time from the CPD church side exterior, first floor, rear lot main side, rear lot cruiser side cameras. See ... The footage shows Higgins. I can't. At Higgins blank in parking lot of the CPD at 1 a.m. enter the building and speak to some unidentified individual on the phone as he is leaving CPD at 1:34 a.m. Significantly, this specifically requested material and evidence which establishes that Higgins was on the phone with someone unidentified individual at 1 a.m. As he left the CPD after O'Keefe's death were suppressed until after and redacted. Yay. Sloppy, lazy, cover up. It was absolute shame for the death of the fellow officer. Just saying, you got that right. This is not justice. If you want justice for O'Keefe, then get justice. But this crap here is just bull crap. Hence why I have the bullshit meter above my head. November 8th, 2024, while preparing for Ms. Reed's second trial in response to continued piecemeal production of the video footage and had not been originally disclosed during the first trial, Attorney Elizabeth Little emailed Special District Attorney Hank Brennan, ADA Brennan, Special ADA Brennan. He is not a real ADA, but anyway, at this point in time, he is. Again, requesting internal raw footage from the CPD. Hello, Miss Morales. Which shall include, but is not limited to, all cameras capturing the interior CPD and or the exterior of the CPD, including all parking areas, evidences, entrances, exits, garages between January 29th at 12 a.m. and January 29th at 11:59 p.m. on November 25th of 2024. ADA Brennan indicated that via email he would request that CPD provide the all requested footage. Bullshit. Ultimately, the defense requested access to the CPD DVR system and drives and holding and recordings from the security system so that the defense expert Matthew Erickson could obtain a video file corresponding logs from the January 2022, 12 a.m. to 11:59 p.m. upon reaching agreement with the Commonwealth. Matthew Erickson visited the CPD on the morning of December 12th to image the DVR system. He then discovered, as the Commonwealth had since concealed, the DVR system program automatically overwrite the footage 30 days. I'm going to rephrase this. Overwrites the footage after 30 days, which means that the Commonwealth has not preserved specifically requested material, exculpatory footage relevant to the case. It's kind of gotten wacky. And we know this. And we know that they had made a motion for the return of the funds that they spent. They said they were sent on a wild goose chase, and they were. And wonderful Auntie Bev denied. January 28th of 2025, the Commonwealth yet again overturned additional CPD surveillance footage from January 29, 2022. This time from an exterior camera depicted Ms. Reed's SUV being brought into the Sally Park garage. See blank blank exhibit M, main driveway side exterior Sally Port. The footage, although blurry and grainy, appears to show an individual approach the right rear taillight of Miss Reed's SUV. Outside. immediately after the vehicle is brought into the Sally Port and exit suddenly. I don't know why that's saved is up there. It's not on you. Okay. Shortly thereafter. If this video was not blurred out, the surveillance feed would have captured yet another angle of the right rear taillight as it entered the Sally Port garage. At a certain point, it gets on. It blank logic, I would say defies logic, that all CPD video surveillance footage coincidentally cuts out, blurs out, and becomes grainy at the precise time the right rear tail light of the Lexus should be framed upon its arrival at the Sally Port. The angle of the video surveillance is exculpatory and was withheld from the defense prior to the first trial. When we just watched, for those of you who are just hopping on, we just watched, and I still have it so I can pull it up, the video footage of when it was pulled in to the Sally Port where it was mirror and inverted. And as soon as it arrived, you have Trooper Proctor and 3 unknown, very much shorter individuals. You can barely see their heads under the vehicle. So they are about my height, 5-something. Moving around. You can see the little heads bopping up and down, but you can't see what they're doing. Very suspicious. And Michael Proctor was right there. And so were other. At one point, there were 5 people around the corner of the rear of that thing. 5 people. B, the facts relating to the CT. Okay, I can't read that. That is all gibberish. Oh, do I have coffee? My coffee is old. I need to get a coffee cup and get coffee. I'll take a pupper break in a minute and do that. I've been having coffee today. McCabe is a key Commonwealth witness. Her blank critical to the Commonwealth's case. On February the 22nd, February 2nd of 22, mere days after O'Keefe's death, the MSP obtained a forensically imaged McCabe cell phone. The forensic examination of McCabe's cell phone revealed a significant exculpatory. I am sorry. And I don't have any kratom. I am out of my gummies. Revealed significant exculpatory evidence supporting Miss Reed's third-party culpability defense, establishing that Miss McCabe Googled husk long to die in cold at 2:27 a.m. This is a big bone of contentions and argument over everybody. And I'm trying to get someone that we know that I can talk to. It's a forensic person to see if they can give me their humble opinion who know nothing about this case. I'm working on it. They still work for a department, so we have to be careful. We may just have to get them off camera voice only. House long to die in the cold, January 29, 22, 3 hours before she supposedly discovered O'Keefe. Body in the snow on her brother-in-law's Brian Albert's front lawn. I've been yawning. McCabe then took steps to delete that one search out of more than 4,560 on her phone. She deletes that one, along with nearly every communication made on her phone in the hours following O'Keefe's death, only some of which were recoverable from her phone forensic extraction software. The close and long-standing relationship between the Alberts and McCabe families and the law enforcement officers assigned to the investigation in this case is central to Miss Reed's third-party culpability defense. CPD Sergeant Lank, a longtime friend of the Alberts, very long-time friend, was the first officer to enter the Alberts residence the morning of January 29, 22, after Miss Jen McCabe ran in to wake them up. In preparation for trial, the defense uncovered location information on McCabe's cell phone, in which proved that she went to first responder Officer Lank's home on January 30th, the very day after O'Keefe's death, redacted per judge's order. On May 7th, 2024, in accordance with this court's order, that parties disclose all information to be used in impeachment process. Attorney Little emailed ADA Lally, ADA McLaughlin to provide location information from McCabe's cell phone to establish that she went to Lank's house January 30th, 22. Unbeknownst to the defense, ADA Lally and ADA McLaughlin shared the impeachment information with Lieutenant Tully. Oh no. Oh no, 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 no. On May 10th of 2024 in a then undocumented meeting, which you're not supposed to have, Lieutenant Lally, ADA Lally, and ADA McLaughlin met with Jen McCabe shortly before she was scheduled to testify in the first trial. McCabe materially inconsistent statement about meeting Sergeant Lank was not memorialized in any report or otherwise disclosed to the defense in advance of Ms. McCabe's testimony at trial in violation of the Brady Gigolo Rule 14. Ms. McCabe testified being on May 17th of 24. During that cross-examination on May 21st, she was on the stand for, I think, 2.5 days. Testified that she received a text from her sister, Nicole Albert, January 29th, 22, stating, "We'll get more info tomorrow. Don't want to text about it." And which she responded, "Right." When Ms. McCabe was asked whether anything significant happened that day, January 30th, 22, Ms. McCabe volunteered the following story, and I'm going to do it.
Why not? I went to O'Keefe's house. On the way home, Carrie Roberts' daughter is a good friend with Michael Lank. So we dropped her off at Michael Lank's house, and Mike's wife came out of the house. Him and Karen are friends, and she, jumped in the car and was consoling Karen and asked how the O'Keefes were doing. And, we talked to her. I might have ran in to go to the bathroom.
Bullshit. On the cross, she said that anyway that she might have ran to go into the bathroom. On cross was the first time McCabe mentioned going to Sergeant Lank's home on January 30th. She admitted that she discussed the issue at the meeting a couple of weeks prior to prior at the DA's office. She testified that at the meeting at the DA's office,
I was asked, were you at Michael Lank's on the 30th? At first I said no, I'd never been in his house. Then I thought about it and didn't say, oh, yes, I did go there. And that was the extent of the conversation.
she further testified that one Tully did not ask her any follow-up questions about why she went to the personal home of Sergeant Lank the day after O'Keefe's death, and that he did not take any notes. Right here.
I was told, no, I was asked, my bad.
The bitch. On May 29th, 2024, only after the defense was deprived of the opportunity. Y'all are getting a potty mouth today. I apologize. I'm trying to get in a better mood. Deprived the opportunity to efficiently cross and examine McCabe and Carrie Roberts. So it was Carrie, not Karen. Carrie and her were in the car. Roberts about their visit to Lank's house. Lieutenant truly memorialized his meeting with McCabe. See ... on May 29 to 24. Reports of Tully interviewing McCabe. Notably, Lieutenant Tully memorialized McCabe's inconsistent claim that she went to Sergeant Lank home.
Pick up.
Carrie Roberts' daughter. Lieutenant Tully, May 29, 24 report which also admitted any reference to McCabe exculpatory statement in which she denied she was ever at the Sergeant Lank's home was not disclosed to the defense until June 4th of 2024, redacted out the butt. An entire page of redactions. I've got to take a little comfort break. We're going to be going a long time. Let's change the music up. We'll be right back. Where? Thank you so much for staying on and waiting for me to get back real quick. I just needed to have a little, I need to get coffee and I got me some popcorn. Lunch. Yes, I did. I sure did. I don't know how I ate much of it, but it's popcorn. Okay, so that's good. Thank you guys for hanging with me today. Oh my gosh, that sounds so good, Haley. It's only 2:30 here, so 2:42. So anyway, Miss Reed's constitutional right effective as of assistance of counsel and due process. Commonwealth engaged in Rule 14 discovery violations and perjury. Miss Reed's constitutional right to effective assistance of counsel and due process under the law as guaranteed by Article 12 of the Manassas. I lived in Manassas, Virginia, so I do that a lot. Massachusetts Declaration of Rights and the 6th and 14th Amendment of the United States Constitution require that the Commonwealth disclose certain evidence in advance of trial. See Art 12, Declaration of Rights of the Massachusetts Constitution, U.S. Code, ... Fresh coffee, y'all. I'm going to feel better in a minute. Under the law guaranteed by Article 12, oh, we already read all that. Defendants has an unquestionable right under the Sixth Amendment and Art 12 of the Manassas Declaration of Rights to obtain relevant evidence that bears to question the guilt or innocence of which and otherwise helps his or her defense. Pursuant to Brady versus Maryland and its progeny, defense counsel is entitled as a matter of due process to all. Okay, we're going back to kindergarten. All means everything. Everything means all. Evidence that is favorable to the accused, material, either guilt or to punishment, including impeachment evidence. Evidence necessary to place the witness in a proper setting to put the weight of the testimony and his credibility to test. United States versus Begley. Brady disclosures also extend to disclose information used to the defendant to attack the reliability of the police investigation, the police methods, employment, and assembling of the case. I guess that's what that says. I don't know what that meant. In addition to her constitutional right, Ms. Reed also has a statutory right to obtain evidence in advance of the trial to prepare for her defense. Massachusetts Rule of Criminal Procedure clearly state the Commonwealth must provide certain mandatory and automatic discovery of evidence within the process, possession, custody, or control. Oh my God, I can't believe. Now you want me wanting steak and mushrooms and thick cut fries with vegetables. That sounds so good. Massachusetts Rules of Criminal Procedure clearly state the Commonwealth must provide the mandatory automatic discovery, possession, custody, and control of the Commonwealth to the defense in order to meet the mandatory discovery obligations. Information subject to such mandatory discovery include, I'll say, all material and relevant police reports, photograph, tangible objects, all intended exhibits, reports, physical examinations of any person or scientific tests or expert statements of persons of the parties intended to call as witnesses. And Commonwealth is also required to provide any facts of exculpatory nature. The rule also states that the defense may move for discovery of other material to relevant evidence not required by subdivision. Mass is blank, blank, blank. Here, on February 2nd, 2022, the Commonwealth was ordered to preserve all physical evidence, including video surveillance footage, in the Sutton District Court. Subsequently, on October 5th of 22, this court ordered Commonwealth to produce all videos in connection with the case and associated metadata. This coffee's hot. Hot to hold and hot to drink. Oh, I don't know how y'all can drink hot coffee so hot that it burns. Notably, this prosecutorial duty to produce evidence covered by Rule 14 extends beyond just the prosecutor, but to all agents of the Commonwealth, including police. Prosecutors shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor or under the prosecutor's direction or control the persons who have participated in the investigation or the evaluating the case, either regularly report to the prosecutor's office have done so in this case. So, do you remember in the Alec Baldwin how his case was dismissed? Yep. It doesn't matter who in the agency has it. It is the ADA's responsibility to know about it, to have it, and to turn it over. Your people screw up, it's on you, boo. Prosecutor's duty to disclose exculpatory evidence extends to evidence in the possession of the police who participated in the investigation, the presentation of case. Well, I'm not going to read all the Maryland versus Rule 14, progeny and Rule 14, Commonwealth production of the April 23rd, 2024 inverted video of the CPD Sallyport garage violated the Rule 14 and the court's order on October 5th of 22. Order compelling the production of video evidence. First comes the Commonwealth violated Rule 14 in this court October 5th order compelling the production of a video evidence by withholding the inverted evidence from Canton Sallyport until after the start of the trial. Here we go. After the start of the trial and after the Commonwealth had already filed a certificate of compliance on April 23rd, 2024. They had it all along. They waited years to get it, and then they didn't produce it until court was in process. At best, the inverted video had been in the Commonwealth's constructive possession since January 29 of 22. All of the Sallyport videos have been in their possession since January 29 of 22. Even though they're saying that they don't have it, it was rewritten over. I'm like, how are you getting the piecemealed stuff if you don't have the original? I don't understand that. And then now you're saying there's a retired investigator detective who has it on a hard drive. And then you say it's on one of your hard drives. I'm confused. At best, the inverted video had been in the Commonwealth's constructive possession since January 29 of 22. At worst, the video evidence was initially manipulated and inverted by the Commonwealth or its agents. Sometimes they're after an effort to defraud the jury into believing. No law enforcement officer approached the right rear taillight of the defendant's SUV upon it arriving at the CD Sallyport. Either way, the Commonwealth production of the inverted video in the middle of trial and after it had filed the certificate of compliance violated Rule 14. Yes, it did, honey boo. I got some. We just got some dropping information.
Breaking news. Breaking news.
I got to get it to share this. Give me a second. I got so much up here, y'all. You guys have no clue how much I have up on my screen right now. Okay, here we go. Into the wild blue yonder. I'm sorry. I'm a military brat. I can't help myself. WZ Verse reported back on October that the special prosecutor, Hank Brennan, was set to make up to $75,000 for his work in trying the Karen Read trial. A public record request was filed by WBZ, reveals that Brennan pay has been increased and will now make up to $225,000 for the work. What? Really? Hank Brennan was hired as a special prosecutor by Norfolk County District Attorney Michael Morrissey in September to retry Karen Read for the second trial. Norfolk Assistant Direct Attorney Adam Lally tried Read's first case and is still on the team trying her second case with ADA Lauren McLaughlin. Hank Brennan contract for Karen Read's case. Brennan was working under a maximum obligation contract would state that his maximum pay would be $225,000 for the case. This amended from the original $75,000. Brennan is being paid $250 an hour, which is below the ongoing rate for private attorneys in Massachusetts. However, I wonder if they have a little thing in there where it says if he wins the case, he gets a bonus. For contract, according to public records, ADA Adam Lally made $145,000 in 2024 for trying this one case. ADA Laura McLaughlin made $119,000 for trying this case. So we're over $500,000, well over $500,000 just for 3 people getting paid to try this case for a second time. Read, 45, accused of hitting Boston police officer boyfriend John O'Keefe with her SUV, leaving him to die in the snow in Canton, Massachusetts, January 2029. Her second trial is scheduled to start April 1st, Thursday. The defense has formally asked Judge Canoni to dismiss the entire case for extraordinary governmental misconduct. Thank you so much, Angela. Angela, you rock. Thank you. Thank you, thank you, thank you, thank you, thank you. I got to get back to this. Get you back on stage. And okay. Can y'all see that okay? So we are after the trial of October 24th, the Commonwealth pronounced previously withheld video surveillance for the CPD church side of the exterior rear camera, lot camera, which showed interior Higgins arriving in the parking lot of the CPD at 1:26 a.m., entering the CPD and then speaking to some identified individual or individuals on the phone as he was leaving CPD at 1:34 a.m. The Commonwealth, namely ADA Lally and ADA McLaughlin's surprise exculpatory impeachment evidence, redacted. Now, why do they keep bringing this? Because I remember correctly, Higgins said he did not talk to any of them when he returned back he wasn't talking on his phone. So I think that's why they keep coming up. Any evidence which tend to impeach credibility of a key position per section witness is clearly exculpatory. Okay, that part was not. Yes, I did. I'm just giving you a different view, bud. If you'd like it on my face better, I can give you that. I can give you that. I can give you that. I could give you that. I could give you that. I was just giving it a little change of view for you guys. If you prefer the face, I'll leave it there. So where was I? This exculpatory video surveillance footage was in the Commonwealth's custody and control since January 29 of 2022. And at the time of trial, it was ADA Lally and ADA McLaughlin's actual possession. By withholding this exculpatory evidence and failing to produce the information until after trial, ADA Lally, ADA McLaughlin, and violated Ms. Reed's constitutional rights as set forth by the Brady. The Commonwealth violated Rule 14 by withholding exculpatory video surveillance. Evident footage establishes that an unidentified person had unfettered access to Miss Reed's right rear taillight of the SUV immediately after its arrival from the Canton PD. Okay, this is important because when we watch the video, which I can bring up again, and I think I shall, you will see that there were not 2 people unidentified, but 5. Let me do I got to do the thingies. I wish I could just flip from one thing to the next, but I can't. It won't let me. I'll embiggen. Make sure you guys can see that. We'll move that here. Okay, so it's in the Sally Port. They just pull it in. I'm going to back it up a little bit so we can see okay, he's getting out of the vehicle. Once again, we're going to watch this. Popcorn moment.
Snow or ice or anything you observe on that vehicle when it came into the Sally Port garage?
Yes, it is.
Just tell me if you could explain from there.
One, we don't know who that person is. I don't think we know who that person is. That's not who I'm worried about right now.
Tell me if you could just pause there for a moment. Sorry.
Other than that's Trooper Proctor and myself.
Okay, so he's
At
okay.
any point in
He's
time
back.
when the video capture
Trooper Proctor's right now at the rear tail light. Right now, he is at the rear tail light. You can see his little head popping up right there. That'd be Trooper Proctor. Who is that other person that just appeared? Now they're going outside. Now you got somebody cleaning up around it. Now you got somebody else coming out. Right there. They're looking at the tail light. So you got one. You got two. I think they had 5 people around that tail light at one point. They're messing with that tail light. My body's coming up and down. There's 3. Look at that third one. That third person is short. Hard to see. Why am I pointing with my finger? You can't see my finger. So you got people bending down. 2 heads real close together right there. There are 3 people around that tail light right now for over a minute. There's the third. You can see the 3 heads. Who are all those people? 3 of them. Now they're all going to powwow around the back of them, congratulating themselves on being screw ups. I've already talked about the stupidity of what they're doing now by cleaning out the Sally port. I've already done that. Okay, let's get back over to the documents. Yeah, yeah. Way too many cooks in the kitchen. Last month on January 28th of 2020, what? Don't know. I'd say 25. Commonwealth provided additional CP surveillance footage. January 29, 22. Okay, maybe it was 22. I don't know. This time from the exterior camera depicting Miss Reed's SUV was driven into the Sallyport garage. This camera angle should have had a clear, unobstructed view of the Sallyport garage. However, yet again, the footage is too blurry and grainy to make out what the conditions of the taillight, notwithstanding the fact that the footage is exculpatory and shows an individual approaching the right rear taillight of Miss Reed's SUV immediately after the vehicle is brought into the Sallyport and then exit shortly thereafter. This video surveillance footage has been in the Commonwealth's possession since January 29 and 22 and was withheld from the defense for 3 years and only produced after trial in this matter. The video surveillance footage directly contradicts Sergeant Butnick's false testimony at trial, in which he claimed that the video surveillance footage establishes that no one from law enforcement approached the right rear taillight of Miss Reed's vehicle. Miss Reed's defense at trial in this matter was that law enforcement removed the taillight material from the Lexus SUV, planted the evidence at 34 Fairview. Notably, no taillight material was found on the crime scene until after they took custody of Miss Reed's vehicle and after it arrived at the Sallyport. That is something that most people are not talking about, and I want to talk about. We hear a lot of court commentators and people like me, YouTube commentators, talking about this case. This, to me, is the epitome of pissing me off. Not one piece of taillight was found at the home of the Alberts until after that car had landed at the Sallyport. Now, I am only speaking from my personal knowledge and information. Hi, baby girl. I'm speaking from my own personal knowledge and information. I am no way considered an expert, but I can speak on what I know and what I believe. If you disagree with me, fine. Disagree with me. Say your negative comments, help my algorithm. Go for it. But give you an example. Back a few years ago, we had a massive snowstorm that hit us. And there was a lot of people who were in fender benders and accidents. And I, being a first responder, did partake in some of the first responder work. And I don't know how she got this, but I'm gonna. Hey, question. Anybody in chat? Let me know the answer to this. I just see on Juror 13, she has the correct version of the video. Let me see if we can find it. Any mod. Can you guys see if you can find the Sally Port video flipped to its original orientation? I don't want to infringe on 13 Juror's page and show her page without permission. Can somebody try and find a link to the original version that's not flipped of the video? And if you can, put it in the in Discord in an instant message. Let me get back to this. So, went to several scenes, and this lady went outside on her back porch and didn't realize it was black ice. She didn't know that the whole porch was iced over and it was a tile floor. And so sometimes, that real big square tile, and she keeps it real polished, so it's always kind of got a sheen to it. And she was carrying a green glass, and she had slipped and fallen, and that glass broke and slid everywhere. And then it proceeded to snow, and she laid there for some time. Poor baby, until she could crawl her way to the door. Even with the snow about an inch to a half an inch to an inch thick that started blowing in on that around the glass, we could see the glass because it was a very bright green and the snow was white, and we could see that. Of course, I went and swept it all up because I didn't want her to have to go out there and do that. But you can't tell me, and someone who's been in a first responder and dealt with accident wrecks and snow and rain and flooding and all of that, if there is red tail light there, it is going to be easily noticeable. And especially if you're moving around and you're kneeling next to the victim, if there's going to be glass, it will be found. Not hours and days and weeks later. I'm just saying. I am just saying. Let me get to my StreamYard comments. I want to make sure. I would love to show this video, but I don't want to get in trouble. And I love Miss 13th Juror, and I don't want her to get mad at me. So maybe if we can find, let me see if I can find. Maybe I can see if I can find it. Because, I mean, it's important. I want to see, well, it's on hers. Deleted by the user. Dag nabbit. Okay, I got it. Yay! I got it. 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 I just got to get the right. There it is. Let me make sure y'all are seeing this. You are. I'm going to bring it over here so I can play it. I haven't seen this, so let's see. Oh, well, I guess that didn't help me much. That don't impress me much. That's not what I wanted. I'm trying to get this video, and I don't. Will I get in trouble for showing hers? I give you credit where credit is due, my love. Okay, y'all go over. We'll just. I'll ask for forgiveness later if I have to. That's not what I want. That's not what I want. Come on. I want this one. This is what I would need. Okay, I guess that's what she played. That's the reversed. Here we go. So this is the one on the left is the correct. The one on the left is this one over here is the correct view. Here you can see, look how grainy all that is. I really wonder. Okay, that didn't do much. All right. I'm done. I'm done with it. But there are way too many cooks in this kitchen. You got that right. Too many cooks in the kitchen. So, any evidence which tends to impeach the credibility of a key prosecution witness is clearly exculpatory. Such as ADA Lally and ADA McLaughlin violated Miss Reed's constitutional rights as set forth by Edzini, whatever, in Maryland, maintaining disclosure of exculpatory evidence. This court, October 5th of 22, ordered compelling the prosecution of video evidence and ethical duties imposed on prosecutors by SJC rule. Withholding this video surveillance footage from the defense at trial, the Commonwealth failed to preserve exculpatory evidence in the violation of the court order of the CPL, include Norfolk District Attorney's Office, and preserve material inculpatory video surveillance footage inserting logs. So yeah, they did bad boo. They did bad boo boo. Yeah, they did bad, and they're still getting away with, which really bothers me. How can they continue to get away with this crap? How can they continue to get away? The Commonwealth failed withholding the surveillance video. Okay, we said that. CPD exclude Norfolk District Attorney to preserve materials culpable. Okay, February 2nd, compelling the District Attorney of all videos. Once again, I want to go back to the word all videos in the Commonwealth possessions and related metadata. Moreover, the metadata and log files underpinning the CPD surveillance footage from January 29, 2022 are clearly exculpatory, and thus the Commonwealth had a constitutional and statutory obligation to preserve the original surveillance footage from the CPD in its entirety. Well, comment away, TKS. We love having you here. Thank you so very much. You guys, I appreciate you loving me. We're trying to grow this channel, and I was hoping to get to 3,000 subscribers by the end of the month, but we got to 2,800. Yay! So now, oh no, we dropped back. See, we did it. We dropped back down to 27.97. This frustrates me because I get to a goal and then it backs away, and I'm like, really? I don't know what's going on with that. So let's try to get me back to 2,800 in subscribers. The clear condition of the right rear tail light of the SUV at the time it entered the law enforcement custody is perhaps one of the most critical and highly contested issue in this case. Yes, we know you have said this many times. The footage has been produced by the Commonwealth is rife with issues that called into question its accuracy and forensic viability of the CPD video surveillance footage obtained from the Sallyport January 29 of 22. The Commonwealth has produced numerous video files without any way to verify the authenticity. Why? Because there is no metadata. The video files include a file captured in the interior of the Sallyport garage with 42-minute gap missing at the precise time in which the feed would have shown the unobstructed view of the right rear taillight of Mrs. Reed at 6,000-pound SUV as it entered into the CPD Sallyport garage, in spite of the fact that the Commonwealth claims a video surveillance feed is motion activated, which we discussed. The mid-trial production of an inverted video produced by the CPD in an attempt to save face with the gap in the footage, which properly depicts the right as left and the left as right, and falsely suggests that no one from the law enforcement approached the right rear tail light, and a blurred out video obstructs what would otherwise, you're getting in my cord, baby girl, be another clear view of the right rear tail light of the SUV as it entered into Sallyport garage January 29, 2022. My dog is running under my feet again. It is not a coincidence that none of many of the cameras of the CFO's Sallyport should be CPD's Valleyport. Garage captured the condition of the right rear tail light. Its arrival to CPD and before the first piece of tail lens material were recovered by law enforcement at 34 Fairview. The fact that the Commonwealth and its agent, CPD, failed to preserve the footage in forensically sound way and allowed critical evidence to be destroyed is not a coincidence and goes to the heart of Miss Reed's defense and credibility of some of the Commonwealth's most central witnesses. They're going to hammer this in. If ADA Lally is not actually aware of the footage, a reasonable prosecutor exercising due diligence would have been made aware. ADA Lally had an ethical, statutory, and constitutional obligation to this footage. Evidence in the possession of the police is a Brady material in which the prosecutor is unaware of it, so the prosecutor has a constitutional duty of inquiry. Following February 2nd, 22, preservation order, ADA Lally should have a diligent prosecutor would have promptly notified CPD to preserve any existing footage and inquire about whether the DVR system otherwise overwrites or deletes old data. Certification of compliance of ADA signed and filed with this court specifically includes a representation that the prosecution made a reasonable inquiry to disclose and make available all discoverable evidence. ADA Lally did anything but. The Commonwealth is responsible for the resulting loss of this critical exculpatory evidence, which cannot be cured short of a dismissal of the case. Okay, we finally got to it. They want the case dismissed. I have a question for y'all. As geared up as we are all getting for this trial April 1st, I would be ecstatic for Karen Reed if it was dismissed, but I'd be a little bummed not to see the second trial because I want to see what they're going to do different. I know a lot of us have said, I don't want to hear another thing about Karen Reed. I don't want to see another trial about Karen Reed. Well, let me tell you, this is going to be nowhere near the first trial. Not at all. Nowhere near that first trial. You got too many new players. You got two new leads on each side of the bar. It is going to be a battle. Number 5, the Commonwealth withheld exculpatory statements by McCabe in flagrant violation of the obligation under Brady Rule 14. The Commonwealth withheld May 10th, 2024 exculpatory statement of McCabe in which she denied traveling to the personal residence of responding officer Sergeant Link on January 30th, 2022. We've already talked about it, but they're going to go into it more. On this day after O'Keefe's death, they claimed that she went to Carrie Roberts to pick up Carrie's daughter. Clearly, the Commonwealth acquired pursuant to their POOC, I don't know what, 14 discovery, Rule 14 discovery obligation to disclose the false statement made by McCabe to Lieutenant Talley regarding her visit to Sergeant Link's home, pursuant to Rule 14. Of a person of the Commonwealth intends to call a witness and any facts of the exculpatory nature, the Commonwealth's decision to preemptively reveal impeachment evidence. And this is where they're coming into problem, because apparently they are not supposed to reveal impeachment evidence. They're not supposed to tamper with the witness's testimony. And that is what the Karen Reed side feels that they have done. Uncovered by the defense to McCabe in advance of her trial testimony, and then withhold her exculpatory statement to law enforcement, it is clear-cut violation of the Commonwealth's constitutional obligation under Brady. Oh, take care and enjoy the film. Let me know what you watch. I've always loved to hear what people watch. The Commonwealth egregious and repeated discovery and Brady violations require dismissal of case with prejudice. When the Commonwealth fails to comply with the discovery obligation, the court has the ability to impose remedial sanctions. For failure to comply with any discovery order issued or imposed pursuant to the rule, the court may make further order of discovery granting continuance or enter such an order as it seems just under the circumstances. Well, if that's going to be left up to Auntie Bev, she's not going to be giving sanctions. She's going to be giving them a reward. Auntie Bev! Clarifying that a permissible order include dismissal of charges without prejudice, emphasis added. Such remedies can include the exclusion of evidence and even dismissal of criminal charges. Blah, blah, blah. Cited. We're going to go down. There is no question that on failure of the Commonwealth to comply with lawful discovery, JEP may impose appropriate sanctions, which may, I'm sorry, my neck needs to pop. Dismissal of criminal charges. Now they're going to say, why is it important for this to happen? Dismissal is appropriate as a remedial. It's important as a remedy in any prejudice caused by a violation of discovery obligation and a fair trial. Such drastic remedy would be approached, therefore, failure to comply with discovery procedures resulting in irreparable harm to the defendant and prevents its possibility of a fair trial. Commonwealth versus Carney. The Supreme Judicial Court identified two parallel legal principles governing when dismissal might be necessary, balancing the right of the defendants against the necessary for preserving the society's interest into the administration of justice. Benjamin versus District Attorney for Suffolk District. First, where the prosecutors failed to disclose evidence, the defendant is entitled to receive the defendant's prejudice by the failure to disclose. Should be allowed to the defendant make the claim showing irredeemable harm to the defendant's opportunity to obtain a fair trial. I already think that's there. I think they would have to really change locations to another country for her to get a fair trial. Alternative pursuant. Oh, and by the way, Karen Reed is like, no, we don't mind if people know about the trial. We just want to make sure they haven't made up their mind about the trial when she was in an interview. Alternatively, prosecutorial misconduct that is egregious. I can't say that word. Deliberate, intentional, or result of violation of constitutional right may be given rise to preemptive prejudice. In such circumstances, dismissal would be appropriate if needed to correct a climate adverse to repetition of a misconduct that would not otherwise exist. Yes. Number one, dismissal, the only appropriate remedy for the Commonwealth's egregious and repeated noncompliance with its discovery obligation. See, this is something that I've been mulling over in my head. They've had at least 4 times that they were told that I know of, or I can remember, that they were told to turn over this evidence. Why has there not been sanctions or anything done when the day before trial and even after trial began, they're still turning over evidence? But yet they're going after the prosecution like a rabid dog on raw meat for little things. Auntie Bev. Yeah, I know. Auntie Bev is driving me crazy. I hate it. You guys, I love social media to a point, but I am tired of people sending me every time they say, thank you, agree with somebody or whatever. I have opted out, but still get notifications from, was it Twitch or Twitter or something like that, with this one person. Every time they click anything, I get notified. And I've tried to turn it off and I can't figure out how. And it's driving me batshit crazy because I'm getting tired of it. It's one of those days. One of those crazy things. So, given to the extreme governmental misconduct in this case, roguish conduct in this case, and the irreparable nature of the harm, irreparable nature of the harm and misread as a respect to the dismissal is appropriate and necessary under both legal principles obtained by the Supreme Judicial Court. Sorry. I love the fact that they put their watermarks, but covering up the words, people. The Commonwealth has detected disclosed evidence that would obligate to disclose Miss Reed's severity prejudiced her, that a fair trial is not possible. It's covered up by this as the gavel drops. Here's Miss Reed has been, if you're going to put that on there, please put it up above where it doesn't affect the reading. I'm not trying to be pissy. I love as the gavel drops, and each mod does it differently, but this is getting tiring. Here, Miss Reed has been irreparably prejudiced by the Commonwealth discovery of violations in the case. The first trial results in a hung jury previously because it was a closed case. By the way, I want their watermarks. They deserve all the credit, and I give them credit. Closing the case. Had the Commonwealth produced the exculpatory footage and the exculpatory statement in which Miss Reed was constitutionally statutory entitled to, the result of the trial may be very well have been different. Instead, the Commonwealth engaged in repeated insistence of withholding exculpatory information from the defense in a concerted effort to undermine the defense's ability to effectively confront and cross-examine the Commonwealth's seminal witness in this case, including Sergeant Bolton McCabe Higgins to U.S. Constitution Amendment number 6. 6. Moreover, the Commonwealth continued the piecemeal production of exculpatory video footage, which has, by definition, been in the Commonwealth's possession since January 29 of 22. It is flagrant violation of the Commonwealth's Constitution and statutory obligation under Rule 14 and Brady. It is well established that suppression by the prosecution of the evidence favorable to the accused upon request violates due process, and it's favorable, not damaging, but favorable to the prosecution or the accused. Favorable to the accused upon the request violates due process where the evidence is material either to guilt or punishment, irrespective of good faith or bad faith or the prosecution. Brady versus Maryland. Commonwealth may not withhold such evidence from the defense. To do so is not only discovery violation, Rule 14, but an also constitutional violation. 12 of the Declaration of Rights of Massachusetts Constitution. Furthermore, the Commonwealth's gamemanship in withholding the exculpatory video surveillance footage from the CPD and failing to properly preserve this exculpatory evidence has irreparably harmed Miss Karen Reed. To this day, the Commonwealth has not produced all of the video surveillance footage records at the CPD on January. CPD, camera angles and large swaths of the time are missing, and the metadata is missing. As a result, the Commonwealth failure to appropriately image and preserve this evidence of video surveillance footage, which should have been captured in condition of Miss Reed's right rear taillight at the time it was taken into PD custody from multiple camera and multiple angles has now been destroyed forever, absent the destruction of this evidence, which has been in the possession of the Commonwealth and its agents since January 29, 2022. I got to pause there because I want to talk about this a little bit more. What I don't hear them talking about, which is irritating the ever living hell out of me, is this. They went and picked up her car at her parents' home. They showed a footage, and I don't have that in front of me, but they showed a footage of the dash cam from the police officer that drove to her parents' house to ascertain her vehicle. And they said as he pulled up, you could see the rear of the vehicle and see the missing taillight, all the missing glass from the taillight. That, I believe, was brought up in court. But after talking to my friends in PD, and I talked to several because I wanted to get their opinions. When you have a vehicle that you're picking up because you have a warrant and that you are putting this under evidence, the first thing you do is you take out a camera and you actually have an evidence person or yourself, but somebody needs and is supposed to video or photograph every angle of the outside of that vehicle. When you open the door to get in the vehicle, if you need to put it on a tow truck, you are to video and photograph that entire area before anybody touches it. Otherwise, you are contaminating the evidence. Or, well, when you open the vehicle and do all that and get in it, you're contaminating it. So before they remove the vehicle, they're supposed to do a lot of documentation. So why wasn't that documentation done? That's what I need and want to know. Why isn't anybody harping on that documentation? Why did the tow truck driver not document? They're supposed to document for themselves. I've had my car towed. I've been on a lot of car scenes where the vehicles were towed. And I have seen and witnessed tow truck drivers asking police officers, have y'all photographed and documented this before I touched it? Yes, we have. It's free to go. They don't take pictures. They said, no, we have not yet. That guy whips out his phone and he's taking pictures. Now, for insurance purposes and other reasons, he's also required to take a picture of the front and rear with the license plate of the vehicle. And he's also normally will open up the vehicle and take pictures of the VIN number. So he doesn't get in trouble and someone says he took the wrong car and he's like, nope, here's the information. Why was none of that done? Why? There is no evidence of the condition of this vehicle when they brought it into their custody. I'm just saying. The defense would have conclusive evidence that Miss Reed's taillight was cracked but not shattered. When it arrived at the conflicted PD, it should be just arrived at PD on January 29, 22. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces. By the way, plastic taillight would not be missing 47 pieces. Nope. I don't believe it. And yes, I've done car body work. I used to be in automotive body work. I've dealt with glass. I've dealt with plastic. I dealt with metal. I've dealt with fiberglass. I've dealt with it all. And I really have a hard time under these conditions. Now, if the tail glass fell out, rear tail light was hit like this guy's did, oh God, yeah, it would have been in a billion pieces. But that's not what happened here. If you don't know what I'm referring to, it's the accident that I was first responder on yesterday. As the Denton police officer, Sergeant Burrows, testified, he observed earlier that day that the Commonwealth claims that Miss Reed had struck Mr. O'Keefe. That evidence would have established Miss Reed's innocence and be case ending for the Commonwealth. What? Denton Police Officer Sergeant Bro testified he observed earlier that day after the Commonwealth claimed Miss Reed had struck Mr. O'Keefe's car. Oh, okay. That should be car in there. That evidence would establish Miss Reed's innocence and be case ending for the Commonwealth. It should not be lost on the court that this video surveillance was destroyed in the Commonwealth's possession on direct violation of the preservation order. As a result, Ms. Reed is left without the ability to forensically examine the CPD ZVR system to determine whether many random clips produced by the Commonwealth in discovery have been altered, manipulated, tampered with, or otherwise clipped have been destroyed. Commonwealth's failure to preserve and produce this exculpatory evidence, which is included in Dresnick original narrative video surveillance footage and accompanying log files, has irreparably harmed Ms. Reed. There's no lesser sanction that can be cured the Commonwealth's failure to preserve the evidence. Exclusion of the video surveillance footage at trial would undermine Mrs. Reed's defense by the footage itself is exculpatory. Wow. Indeed, the very nature of this evidence, such as exclusion of harm, than helps Miss Reed. The exculpatory evidence to which Miss Reed's constitutionally entitled to permanent she's entitled to permanently, thank you, loss. Therefore, the Commonwealth's misplaced car, I can't read. So basically what they're saying here is that this will help her. How can they put a defense on if they don't have the evidence? By those who are watching on Facebook and on X, thank you so much. You are allowed to comment. You can't. I've got to go in and do this. My bad. I apologize to you guys in Facebook world because I think I forgot to do this. Let me go double check. I have to go in every time I am live and edit the video to make it public, which drives me crazy because it's not fair. Because unless I do that, and I apologize, and I got some of you watching over here, I apologize. You guys can now leave comments. I appreciate you sharing. You can thumbs up. I'm going to say hello. Just to make sure the comments are working on my end. I'm going to close this out because I can't. Yep, it is. Okay. Yay, everything's working. Woohoo! That doesn't always happen well. Okay. Where was I? Even if the court disagrees that Ms. Reed has been irreparably harmed, the Commonwealth's misconduct gives rise to a presumptive prejudice and that warrants a dismissal. The misconduct by the Commonwealth in this case was egregious, deliberate, and intentional. These were not innocent mistakes, and that's the key here. It wasn't, oops, well, when we took the video from the computer and put it into the PowerPoint presentation, it got inverted. Bullcrap, because everything, all the documentation of the date timestamp on the bottom is readable. The video itself is reversed. If that had happened, all of it would be mirrored and all the lettering would have been backwards. So I just cannot accept that. The repeated and flagrant discovery violations engaged by the Commonwealth and its agents were intentional and designed to bring about a wrongful conviction. It definitely was misleading, especially on that mirrored video. Here at trial, ADA Lally and the Commonwealth and its agents intentionally withheld video surveillance footage from January 29 to 22. The Commonwealth sprung an inverted surveillance footage on the defense in the middle of trial in violation of Rule 14, as well as a certificate of compliance. And then its compounded violation by attempting to perpetuate a fraud on the court and the jury. This here, I believe, right there, then in and of itself should be in Karen Reed's favor, and they should dismiss with prejudice because they had this video. They were told 4 times, if not more, to produce any and all video. They did spring it on the defense in the middle of trial. And some smart cookie noticed it was inverted. The video itself was inverted, but not the date time stamp. It was readable. And it was all the certification and metadata is gone. So it is a multiple compounded violation. And they tried to fraud the jury, the court, and everybody that's seen it as it being true and accurate, because that's what they swore to under oath. This is true and accurate representation. And it was not. And they knew it was not. By knowingly elicit false testimony by Sergeant Butnick, on direct examination, the Commonwealth violated the ethical probe, against the presenting knowingly false evidence to their fact. The inverted footage of Miss Reed's vehicle from its interior Sally Port camera was unquestionably a false account of true facts, and the Commonwealth passed it off as an accurate depiction of the SUV when it arrived in the CPD on January 29, 2022. And that, as seen in the video, enforcement officers approached the right rear tail light, 5 of them at one point. 2 out of the 3 that you saw were shorter than the vehicle, so you saw their heads bobbing up, and they go down like they're squatting. They disappear. When they stand up, you just see the tip of their head, and then you see them go down, and then they pop up over here. So to me, they were doing something. And they weren't just standing and looking at it. They were up and down. Moreover, both ADA Lally and ADA McClellan were caught withholding exculpatory information from the defense at the first trial. The Commonwealth understand the decision to suppress surreptitiously revealed impeachment evidence to Miss Cabe in advance of her trial testimony, and then withhold her exculpatory statement to law enforcement is a gross violation of the Commonwealth constitutional obligation of the Brady, as it is progeny. Yeah, that really bothered me. I didn't know that was going on, but when the defense went in and did try to impeach her, I realized what was happening, and I just wanted to scream. It was horrible. Even after trial, ADA Brennan located exculpatory video surveillance footage, which was withheld from the defense at the first trial, and established that Higgins made a phone call at 1:34 a.m. outside of the Canton PD. And people keep, and I've had someone on my other, which y'all can't see those comments, only I can. And they say, why do people care about that phone call? Are you under there? Oh, I'm sorry, baby. I didn't know you were there. Because he said he didn't make any phone calls. But the problem is nobody knows whom he called. And he said he didn't call anyone. Why would you say you didn't call anyone and turn around and say that you didn't call anyone, and then you were on video, and that video is produced after trial, calling someone? It is just a piece of work is what it is. My bangs are tickling me too much. I'm going to see if I can do a side. There we go. I need a piece of gum after that popcorn. The exculpatory impeachment material was never turned over to the defense. Redacted. The Commonwealth. Oh, thank you, Patty. Oh my gosh. Yeah, I'm way demonetized. I'm so way demonetized on this. And that also gets you a bunch of entries into the March giveaway. And I'll put you into today's as well. Thank you so much. I love and appreciate all of you who do that for me. I don't get these very often. So thank you, Patty. You are in the drawing for today, for the February and in March. because it's a leap year. We're going to do 2 days in one. Thank you, June. Thank you, Jesse. You're in. I lost my place. Oh, indeed, as discussed above, the Commonwealth's misconduct as resulted in the violation of Ms. Reed's constitutional rights. So, as to give rise to the presumptive prejudice, the discovery violations in this case constitute a Brady violation and thus violates Ms. Reed's due process rights. To establish a violation of the rule of Brady in Maryland, incorporated in Rule 14, the defendant must demonstrate upon review the evidence actually exists. The evidence would have tended to exculpatory. Oh, Jesse, thank you so much, beloved. Oh, thank you so much for the gifted membership. Oh, Alita Lee, you were gifted. Thank you so much, Jesse. We love you. Love and blessings. I got to do it because I want to, and I worked hard on these clips. Let's see, which one do I want to do? Do that one? Thank you for your super chat. Thank you so much for your support. I know, I'm in a silly mood. It started off good today. I almost had a fight with a rich person out in the middle of the parking lot because they were being entitled assholes. That's what they were. But I was a good girl, partially. Indeed, discussion above Commonwealth Miss Sons. I lost my place. Price of Brady. To establish a violation of rule of Brady versus Maryland, as incorporated in Rule 14, the defendant must demonstrate upon review of the evidence actually existed. And it did. The evidence would have tended to exculpate. It would have. And that the Commonwealth failed to disclose it upon proper request, and they did, 4 that I could count. So, given these facts, given rise to the presumptive justice and the conjure, I guess, is needed to create a climate adverse to repetition of misconduct. I'm going to have to it's hard to read because some of this stuff is garbled. This case should be I don't even know what all of that is. Should not be to proceed with trial or create a climate in which these type of flagrant constitution statutory violations are regarded as permissible. Such an outcome cannot be tolerated by the court. And of course, guess who decides all this? Auntie Bev. Auntie Bev gets to decide this. I don't think it's right. I don't think that if there's a mistrial, that the same judge should proceed over the same trial again. In my humble opinion, I think if there's a mistrial, you get a whole new judge, especially when you got one that's familiar with all the players involved and refuses to recuse herself. By the way, there is a petition going around. If you should happen to come across it, and if you wish to sign it, it is a petition to the whomever, I think it's the Supreme Judicial Court of Massachusetts, to have her removed. The Commonwealth, it's not going to happen. Clear repeat and intentional failure to comply with discovery orders require an appropriate remedy in this case, because the discovery violation concerns 2 failures to produce and preserve exculpatory evidence. There was 4 requests, 2 demands out of those 4. And because the exculpatory cannot remedy the violation, the only appropriate remedy is dismissal of the case. See, the problem is, if the prosecution should magically produce, and I'm going to change camera angles so y'all don't get bored, magically produce this evidence, all the videos with metadata and all of that, they're screwed. So even if they had it and they tried to produce it, they're screwed. They're screwing themselves. It's a damned if you do, damned if you don't. Because if they don't do it, and it's found as contempt of court and a bunch of other stuff. But if they produce it, it's contempt of court and a bunch of other stuff and a loss of trial no matter what you do. So they're in a position, Mr. Brennan is in a very odd position, and it's a damned if you do, damned if you don't. Maybe that's why he went from 75,000 to 250,000 in pay for this trial. Thank you for liking, Patty. Just saying. Because the Commonwealth egregious misconduct, including repeat and intentional delays in providing discovery, the withholding of material and exculpatory evidence, the failure to comply with court orders regarding discovery, Ms. Reed's constitutional right to a fair trial has been irreversibly harmed. And this dyslexic girl just got that right. Hallelujah. And thank you so much. It caught you. No proceeding against her can satisfy the constitutional requirement of the fair trial. The defendant therefore respectfully requests the Honorable Court to order the case to be dismissed with prejudice. Dismissal is only appropriate remedy for the violation of Miss Reed's Sixth Amendment right to trial by an integral jury. Dismissal. Additionally, dismissal of this case also required a remedy to the violation of Miss Reed's Sixth Amendment right to an impartial jury, redacted like crazy. See, that looks great as the gavel drops. Thank you so much. Notably, a jury may never be dismissed because of their views on the case or for the reasons of having to do with their relationship with the juror. Mistrial may only be dismissed for for reasons personal to the juror. Okay, so we had 2 jurors dismissed right off of the bat in deliberation. So we're going to get into that, I believe. Not having to do with the views of the case and the relationship with the jurors. Commonwealth, case law out the airs. Jury tampering such as this is presumptively prejudicial and triggers a burden to the government to prove that the tampering was harmless to the defendant. The Commonwealth cannot do so here. Redacted. As per Massachusetts law, courts do have the discretion to dismiss jurors when doing so would be in the best interest of justice. Judge can do this at any time during the trial process, although the procedural burden and standards vary at various stages. The post-implement of pre-deliberation, if a judge is alerted to a potential misconduct of or affecting jurors, the judge first determines whether it's material, raises serious questions of possible prejudice. So what they're saying here, the judge does have discretion to dismiss, but there has to be a procedure and there has to be a clear reason. It has to be in a position to where it would prejudice the jury or juror against the defendant, or well, I guess the prosecution too. She so denotes or whatever. She must be then hold an inquiry about the misconduct, and there's a huge redaction. Ultimately, Ms. Reed's Sixth Amendment right to an impartial jury untitled her to certain procedural protections when it comes to dismissal of jurors. The procedural protections were not provided here. Redaction. The constitutional violation, along with the egregious discovery violations discussed above, demonstrate the inherent unfairness of the proceedings against Ms. Reed and warrants dismissal of case against her. We're coming to a conclusion. Yay! Let's get a clap on that one, y'all. We're coming to a conclusion. I don't know how many pages I have read, but I've read a lot. This is not the 600-page document, I don't believe, but it may be. I don't know. In conclusion, for those above reasons, Ms. Reed respectfully requests that the Honorable Court grants defendant's motion to dismiss for extraordinary governmental misconduct and prejudice, although the dismissal is required and appropriate under the circumstances. In alternative, the defense seeks and is entitled to an evidentiary hearing on these issues attended to the Brady violations and the juror interference. That evidentiary hearing will be required testimony from a number of witnesses, including but not limited to AGA Lowry, AGA McLaughlin, A.L. Allen Brennan, Lieutenant Tully, Chief Rafferty, Trooper Proctor, Sergeant Brutnick, Colin Crawford, and members of the CPD and Steve Fanning. So what they're saying here is that we have a right to a hearing, and these are the people we're going to call to witness. Y'all, that I would pay to see. I would pay to see that in a nanosecond. I would pay to see that. Okay, guys. I am going to have to take a quick comfort break. I've been on all afternoon. We will be back. Everybody take a stretch break, take a comfort break. We will be back in a minute. I think everybody, let's go to this one. break I desperately needed. I appreciate each and every one of you. And I really am thankful that a lot of you fully understand the energy and efforts it takes to do this. And y'all are so kind in affording me the ability to get up and stretch, go do a comfort break. I may need to do it again, but as y'all know, it's a long day sitting here doing this, and I absolutely love it, and I'm grateful to be able to do this. Thank you again, Patty Hoffman and Jesse, for your kind support and your super chat, and also in your gifting membership. Thank you so, so very much in support of this channel. I really would love to hit March with 3,000 by the end of March. My goal is to be at 10,000 at the end of the year of super chats. I'm taking a medication. No, it's a kratom gummy. It really helps with discomfort. I have rheumatoid arthritis and it is being very not happy right now. My feet are really affected at the moment. And kratom is one thing that I can take and not have any kind of side effects on my side. On my end. Okay, so we are now at the Commonwealth of Massachusetts Superior Court, affidavit of Alan Jackson, Esquire, to support the defendant Karen Reed's motion to dismiss. So now we got some affidavits, and we're going to go over them because I haven't seen them. I, Alan Jackson, Esquire, under oath, do depose the states as follows. I am a partner at the firm of Worksman, Jackson, and Quinn, representing defendant Karen Reed. Prohavix. Can someone tell me how to say that? Can someone please tell me how to say this? I don't know how to say it. Once again, it's the dyslexia kicking in. So if you can put it, I don't care. Type it in how it sounds, not how you say it, not how it's, you know what I mean, phonetically. I've received the discovery. I submitted this affidavit on a personal knowledge and support of defendant Karen Reed's motion to dismiss for extraordinary governmental misconduct. I have reviewed. Oh, you have? Congratulations. You have reviewed the discovery produced by the Commonwealth in connection with this case. There is significant exculpatory evidence which has been in the Commonwealth's possession since January 29th, 2022, withheld from the defense in the first trial. Number 4, the facts set forth in the instant motion to dismiss the extraordinary governmental misconduct are true and correct to the best of my knowledge. My knowledge is important. Attached here to Exhibit 8 is a true and correct copy of the Salton District Court February 22nd, 2022 order allowing the defendant's emergency motion for preservation of evidence. Attached here to Exhibit B is the true and correct copy of this court's October 5th, 2022 order allowing, in part, defendant motion to compel discovery. Of course, we have number 7 is now redacted. Of course, it would be redacted. I have somebody I know, her name is Misty. She had a baby at 20 something weeks or 30 weeks. 30 weeks, I think 30 weeks. And the baby's first name is Halo, and he is doing well. Oh, look how beautiful. I am not going to show y'all because of her face, and I can show you that one. The little one is hanging in there, growing. Congratulations, love. I am so happy for you, but you are doing the NICU thing, and it is a rainbow baby. So thank God. And I'm very blessed and happy to see that you are striving, that he is thriving and improving. So congratulations and continued prayer. Okay, back to it. Attached here to Exhibit D, Exhibit I, Exhibit J, Exhibit O, Exhibit S are true and correct copies of excerpts and transcripts from the first trial, Commonwealth versus Karen Reed. Attached here as to Exhibit E, Exhibit H, Exhibit K, Exhibit M. Yes, I'm making fun because it's redundant. Copies of the video surveillance from the Canton Police. Oh, wait, do we have that? Oh, it would be nice if we had it, but I don't think we do. January 29, 2022, which were produced in discovery of the Commonwealth on April 24th, the day before trial, April 23rd, in the middle of trial, October of 24th, way after trial, and January 28th, year after trial. Almost a year. Prohokvice. Prohakvis. Prohakvis. Thank you so much, June. I had somebody make a comment that if I can't read, then I shouldn't be reading, and I needed to shut up. First of all, I'd like to see you tell people like EDB to do that because she's dyslexic like I am. I'm older than her. She's dyslexic like me. And doing what we're doing is very hard. It also helps me improve reading out loud under this kind of pressure. I like vice president. So Prohak vice. Okay, thank you. So I'm proud of myself because a year ago I wouldn't read like this in front of anybody. So thank you for boosting my algorithm for your negative comment. Prohawk Vice. Got it. You're so awesome. See, that's how I need it if I can't figure it out. Attached here to Exhibit P is a true and correct copy of Lieutenant Brian Tully's something 24 report memorializing his May 10th, 2024 interview with Jennifer McCabe, which is not produced to the defense until June 4th of 24, part of the not XLV, which is the report was not produced until after Jennifer McCabe had already testified in the Commonwealth. On October 10th, I hope that wasn't too loud. I can't control the volume on that. Or can I? Yeah, I can. On October 10th, after trial, the matter had concluded. The Commonwealth produced additional exculpatory video surveillance footage to the from the Canton PD, established that Brian Higgins made a phone call to some identified individual on January 29, 2022 at 1:34 a.m. That's when you get a warrant and figure out who the phone number is, and you can find out who he called. And that I would love to know. Oh, was that one of the butt dials? Was that the butt dial? We haven't talked about the butt dials, have we? This video surveillance footage, which is attached to here to Exhibit K, was not produced by the Commonwealth until after trial on October 10th, 2024, I'm going to say. Connection with NOD XLV 11 and Special Prosecuting Attorney Hank Brennan indicated that he located this video footage in some sort of electronic device in a box that was in the prosecution, it was in the possession of the Norfolk County District Attorney's Office while he was conducting his review of the discovery in the case. Oh, that right there. This right there should have had the whole thing thrown out, in my humble opinion. Yeah, well, thank you, June, because really, people don't understand. See, when I have this, what you're seeing is I do better with black with white lettering. Can't do that here. That's why you see me graying it out a lot because the contrast and it helps. But when I look at this, the letters start kind of doing this kind of wavy thing and my letters are inverted. So it's very difficult. So sometimes you'll see me highlighting sections to help my reading. The defense set forth a credible and unaccessible evidence establishing that the Commonwealth has engaged in the numerous okay, now I'm struggling with this because it got smaller, and I'll do better the bigger the print. Egregious Brady violations through the pendency of this case. The Commonwealth's repeated constitutional and discovery violations, which have ultimately resulted in the permanent destruction of exculpatory evidence, has caused Ms. Reed to suffer irreparable harm, and a fair trial is simply not possible. Redacted. Ms. Reed has suffered numerous why do they keep using this word? Gurgacious. Is the E silent? Gurgacious? Let me know if that E is silent. I think it's gurgacious if I'm saying it correctly. Constitutional violation as a result of the Commonwealth's brazen discovery and constitutional violations and juror interference, which denied Ms. Reed her Sixth Amendment right to a fair trial by an impartial jury. The interest of the justice required that this court exercise its discretion to dismiss the case with prejudice. In alternative, the defense respectfully, I'm going to underline this so I can make sure I get it right. The defense respectfully requests that the court grant her evidentiary hearing such that the defense can call witnesses so further established through sworn testimony the Brady violation and the juror interference have occurred in this case. Oh, egregious. Egregious. Is that how you say it? Egregious? It looks like egregious. Okay, egregious. Thank you. See, that's all I needed. You're awesome, Jesse. Signed, sealed, delivered. It's yours. Now we got another. Preservation of evidence. The defendant's emergency motion for okay. So now comes the defendant, Karen Reed, and hereby moves the Honorable Court to order Commonwealth to preserve the following in connection with the matter. So this here is February 2. Egregious. Did I say it right? Egregious? Thank you. And basically, it says all notes of any law enforcement, I'm going to say material, or state trooper of any and all witness interview, including notes of any of the defendants alleged to have said the defendant has specifically his court or ordered to such notes heard. Okay. Egregious. Thank you. All notes, that may become my new favorite word. That's egregious. All notes, any law enforcement. I'm getting tired of this stuff. Regarding the investigation, the defendant is especially. So basically, they're saying, okay, let's turn down here. All tapes from any local police departments, Massachusetts State Police, regarding this matter from the first time the police were contacted to the arrest of the defendant. So right here, there it is. 911 recordings in this matter. All trace evidence, including not limited to fingerprints, DNA, blood, saliva, any other bodily fluids. Oh, yeah, like many soldiers. The defendant is specifically moving this court to order that no exhaustive testing should be performed on any evidence in connection with this case without the Commonwealth giving prior notice to the defendant and allowing the defendant to should be object. All physical evidence, including anything presented or near the decedent at the decedent at the blank, his body was discovered. I say where his body was discovered at unaliving found alleged sign. I don't know. So there it is, and this is the affidavit of counsel support. Defendant's emergency motion. So I, David Yerna, do hereby dispose the state at the following is true to the best of my knowledge. Here's his, this is going to nail him. I am an attorney licensed to practice in Massachusetts since December 1989. My office address, blah, 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 on blah, blah request for preservation of evidence made within the motion are reasonable and would prevent the destruction of potentially exculpatory evidence. I believe that it is in the interest of justice for this court to allow this motion. So not only is he saying, I agree to it, I'm encouraging you to allow it. We'll do it. No big problem. Second day of February 2022. So why in the hell do you not have all the videos? Why is it being piecemealed? Why are the videos inverted? What the hell? So I'm not going to read all this, but on September 16th, so they had the motion in February to ensure it to be saved. Now on September 16th, you have a motion to compel discovery, which means, I'll read a little bit of it. Now comes the defendant, Miss Karen Reed, respectfully notes his honorable court. All documents related to the chain of custody and otherwise officially prepared by law enforcement in connection with the case. All call logs, all dispatch records, all call logs, tapes, complete records of all. So it's really garbled, but in other words, everything. And it says allowed, it's got numbers. So this is the first one. Then the second one comes down again on, when did this one drop? So that was September. So this is September 15th. So it was ordered. So they requested it again. It was ordered. Exhibit EC is total redaction. Total redaction, and Exhibit D. Continue testimony of York Yearly Burtnick. Oh. They requested his testimony. And we can't read it all. 5 a.m., few seconds until the video, blank, blank, blank time. Would you estimate the elapse of the video in real time? Something, maybe something, you see something in the blank of something appeared next to blank. It is very incomplete. I can't read this. Can you? So it's kind of like a transcript, and I can't read that. I can go it down here. Let's see. The court, this is the last time. Would you please? The witness, thank you, Your Honor. Mr. Jackson, what is the time that is time stamped and the video was paused?
5:50:46.
5:50:46 p.m., correct?
That's correct.
So it appears that this video has about 10-second jump, 42 minutes to the 5:50 mark, correct?
I don't know how much it jumps.
Well, from 5:08 approximately to 5:50 approximately, how much time is
Approximately 48.
42 minutes?
Excuse me, 42 minutes.
That okay, Miss? Please, which 18 shows right near the tail light. Okay. There is a vehicle that appears to be in the individual standing vehicle. Is it? It's not just the tail light that appears, but Sergeant, the exact time that would show the Trooper Proctor was doing at the right rear tail light is missing.
Objection.
Sustained.
The exact, so this goes on. We've already seen this. We've seen it in real time. Exhibit F, Commonwealth Certificate of Compliance. In accordance to Massachusetts Rule Criminal Procedure 14A3, the Commonwealth indicates that the court, to the best of its knowledge and after reasonable inquiry, it has disclosed and made available all
Subject to discovery.
Here's where they said that they had given them everything, the identity of each item provided, see Commonwealths. Then we got another exhibit that's, we're just keep going down. 26th day before trial, Honorable Corey Kennedy. Okay, these are all the, I'm looking to see if we have, I'm not going to read the transcripts because I guess we're not going to have videos. What was that? We've got over 600 pages in another file to go through. So all of this has been, okay, we're done with this. All of that has been extracted. We can do no more on this one. Yay! We did it. We got through it. Now the next. And let me get this up and going. Make me double check and make sure it's good to go. No, I don't want to share screen. Not there anyway. So there we go. Let me resize it so we can make it embiggen for you. Why is it not doing what I want? I guess that's what I'll have to do. Okay, we're going to reset the counter because this is a one that is really mistyped. It's not a conversion issue. Responded to Norfolk Supported petition of writ of habeas corpus on July 24th. The petitioner criminal trial Massachusetts State Court ended when the judge declared mistrial onto the jury. Deadlocked. The petitioner claims that double jeopardy clause in the United States competition bar retrial on the two of the three charges that faces, because as to those two charges, there's no manifest necessity for the mistrial, and statements purportedly made by the jurors after the mistrial showed that the jury unanimously agreed she was not guilty. In the alternative, she seeks a post-trial inquiry of the jurors. Now okay, which voice is creepy?
You are my precious.
That one?
Precious is back. Actually, this reminds me of Precious in The Lord of the Rings. My precious.
Okay, did I creep you out much? If my friend is at a race and I'm not, I'm going to be pissed off at her. Okay, and you didn't invite me. Why? Why? I love NASCAR racing, and my friend is at a NASCAR race, and I'm pissed off because it's here in Texas, and she didn't even ask if I wanted to go. Bitch, please. So anyway, petitioner claims a double jeopardy. Okay, not guilty. In the alternative, she's taking a post-trial inquiry of the jurors. We know that's not going to happen. The claim having been rejected by the merits of the Massachusetts. Basically, this whole thing is all about the juror letters, and we've talked this to death almost, so I don't really want to go over all of it. But one of the things that I do want you to do is kind of let this fuel me for some conversation. The thing is I do have, let's go ahead. I'd rather look at this. Let me pull this up. Nope, that's not what I want. That's what I want. Okay, this is, and it's got this weird crap over it on this first part, but this is the actual evidence. These are the actual notes that were handwritten. We can't read the first one. I hate it when it does that, but the second one we can. Judge Canone, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by the fundamental differences in our opinion and state of mind. The divergence of our views are not rooted in the lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to the point that we are in the senses is unattainable. We recognize the weight of this admission and the implications it holds. Redacted juror. And then we go down here, and once again, it does not say, it says, well, let me go back up there and say, okay, so it was it in the first one it said it, I am writing to, we have, best our exhausted review of the evidence and diligent consideration of all. We are unable to reach okay, and it says reach a unanimous verdict. Not all, but they're reading that as all. So down here we have the third one, Judge Canone. It kind of looks like the same handwriting, just different pens. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the element of charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort and diligence, but rather since an adherence to our individual principles and moral convictions. Once again, it's not about your moral, well, it kind of is, but I'll talk about that in a minute. To continue to deliberate will be futile and only serve to force us to compromise these deeply held beliefs. This is the note that was not shown to the defense or the prosecution when Judge Canone then looks at it, calls in the jury and says, reads this note. And then as soon as she says to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. And she looks at him, and I'm not going to do that to you. I'm calling a mistrial. Boom. You are excused to go back to the jury room where I will meet you shortly. I think some of these documents, and I think Jesse said it was right. Whoever did, they're being converted from a PDF to I think it's conversion. However, that said, I will tell you that the one that I'm reading right now that's in front of me at this moment, there are actual typos. It is not a conversion. It is actual typos, not the conversion. So this one right here is not a conversion. There are actual typos. There's conversion too, I'm sure. That's not going to work. Let me try to embiggen it more. That's not going to work. I really get tired. I wish I am on a PC, not a Mac. I love Mac, but I'm not on a Mac. Mac. But my problem is getting this to read in a way, and I have to constantly readjust everything. I need to program. See, it's difficult. It won't let me. Well, let me do this. I hate to do this, but I will. I'll do a 100. See how tiny it is at 100%? And if I do this, it cuts it off. So I'm perplexed. I'm trying to give you all the full scene, but I can't. This is the size I need it to read it comfortably. Okay, so she continued to tell them to deliberate. We've already talked about all this. Deliberation extended through Friday afternoon. We've read this already. So this, of course, was denied. It won't be any night. We've already read that one. Affidavit of counsel in support of motion. We read that one. There's a lot of mistakes on here. Did we read this one? No, this is Yanetti's. We'll read this one. Oh, my ear is constantly. Someone asked why do sometimes I put a Q-tip in my ear? Because when you wear these hearing aids and earbuds and such, it gets to the point to where it builds up warmth and moisture, and it itches and tickles, and it's like having water in your ear, and it is very, very disconcerting and irritating. So, yeah, I know. And people talk to me all the time about putting it in my ear. Look, I'm not putting it down where it shouldn't be. I love all my mothers. I love all my mothers. I love all my fathers. I'm having to resize everything, guys. Please be patient. Okay, maybe that helps. I have a lot of people mothering me, which is cool. I'm used to it. It makes me feel loved. Nope, this will be heard next week in front of Canoni. Yes, it will. That is court. I thought this went to the federal appellate court because it refers to SJC. Nope. Okay, let's look at this. I, David R. Yannetti, do hereby dispose the state of the following is true to the best of my knowledge. I'm an attorney licensed, yada, yada, yada. Yesterday, February 26th, Special Agent District Attorney Hank Brennan called my cell phone at 4:21 p.m. I could not answer the call at the time, so I texted him with a promise to return the phone call. At 5:47 p.m., I called back. He informed that the Commonwealth would be producing a chain of custody reports. This is where I go ballistic. He said that we would wait it for a motion to dismiss. We would want it for a motion to dismiss, so he wants to get it to a fourth writ. I asked if he could give me a better idea of the God Almighty fix it time frame within which we would receive it. He said it would have to be tomorrow. Mm-hmm. Correct. It would be like for tomorrow, the 27th of February, yesterday. But that time, Sergeant responsible, sorry guys, I got to do this. But that time, but that the sergeant responsible for drafting it is retired, and it was unclear how long it would take him to finish the report. Why is he having to finish a report? That person should be subpoenaed, come into court, show your face, brother, and explain to us how you have been holding on to all this video evidence for all this time. If you're retired, you shouldn't have any of this, in my humble opinion. He did say that he would definitely have it by the end of the week. Followed up with a phone call to Mr. Brennan today, and we connected. He informed me that there would actually be 2 chain of custody reports, both of which he expects to be produced by the defense by tomorrow morning, which is today. Or was that yesterday? That was yesterday. Be produced by yesterday. That he would be producing Monday morning, then asked whether it would be new video, beyond which he replied he did not know yet. Why am I not able to extract any more from that paragraph? Wait a minute. Let me see something. Is there more? Let me do something real quick, guys. I'm going to bring this down and see if I can. Nope, there's no more to be had. Dagnabbit. I was hoping there'd be more to be had. And there's not. Phone call, he further informed me there might be Sallyport videos we already have, he replied. Number 8, Monday morning, March 3rd, 2024. Oral is currently scheduled for March 4th. Until we receive both chains of custody, our motions to dismiss is incomplete. After receiving the discovery, we will need to analyze it, confer with motions to dismiss by filing an addendum. In the light of other deadlines, we are working our reciprocal discovery obligations. The defense, or 2 days to modify its motions to dismiss argument. Believe it is number 11. Believe it is in the interest of justice that the court schedule order to allow the defense an oral argument on motion any day during the week of March 17th. Signed, sealed, delivered. I'm yours. So that was that. And then we have, I don't want to save it. Just close. No, I do not wish to save. Just close. Thank you very much. Okay. Commonwealth opposition to the defendant's motion to amend the court schedule order to February the 10th. So he's saying, no, buddy, you're screwed. Now comes the Commonwealth respectfully requesting honorable court deny the defendant's request to continue a non-evidentiary motion hearing on the defendant's motion to dismiss extraordinary governmental misconduct. In accordance with the scheduling order, the Commonwealth filed its opposition on Friday, 27th of 2025. The Commonwealth objects to any continuance and will be something to address this motion Tuesday, March 4th. Of course, you're going to deny it. So Tuesday is going to be one spicy day. One spicy day. We got through it all, guys. It only took me all afternoon. So what are your thoughts? What's going on? So let me pull up what I know the court scheduled to be. Not too sure if it's 100% accurate, so don't hold me to it. If it is not accurate and you have information I do not, please share it in the comments. But right now, as I pull up the calendar, get my personal calendar out of the way, get the court calendar up and going. Okay, I have right now 10 a.m., 9 a.m. our time on Tuesday. Miss Karen Reed, 8 a.m. It may not be, but it's set for, I have it. I have Karen Reed on Tuesday the 4th, Wednesday the 5th, and Friday the 7th. Then I have Miss Karen Reed again on the 18th. Then we have Miss Karen Reed's trial starting March 1st. By the way, my birthday is March 26th. This is my birthday month. We will be celebrating my birthday month. I will be giving away a special birthday month gift to each one of you. And then in a couple of months, now I'm going to, and this is the other thing. I am also going to celebrate my YouTube birthday month, but when I'm celebrating it is when we became monetized. That is when my channel, I feel, officially was a full-blown YouTube channel. We did start doing stuff in March, April timeframe, but I feel that the appropriate time to celebrate my 1-year anniversary will be the month that we were monetized. But we will do a birthday celebration here in studio on the 26th of March if someone doesn't want to take me. And now, if I get a date, if I get me a man and a date before then, this chick will be gone, boom, bye-bye, and we will celebrate the day before, the day after. In other words, guys, snowball's chance in hell. We'll see you here on the 26th. I know it's crazy. Your birthday is Monday, Kathy L. Oh my gosh. Monday makes it what? The 3rd? Do you know what, honey boo? Come on. Tell me it's your birthday on the 3rd, and I will sing to you or sign to you happy birthday. We will celebrate it with you. Even if you just come in for the birthday wishes, we will celebrate birthday. I love celebrating birthdays, y'all. So please tell me when it's your birthdays. I don't care if it's grandchildren, if it's family, if it's a birthday. Tell me it's a birthday. It's your birthday. It's your birthday. Okay, guys. Easter Sunday is the 20th of April. I have had Easter, I think, twice on my birthday in my life. And I don't think it's going to happen again before I die. I looked it up. I'll be way gone, which sucked. Why did it go back to May? Go to today. Thank you very much. I am looking forward to St. Patty's Day. I may wear this. I don't know. I may get me a St. Patty's Day shirt. Who knows? Okay, guys. Daylight savings time is March 9th. This week, we have a special, and I'm going to have to end this in a minute because I got to prepare for it. A special guest. We're having Tanika with your 2 cents. She's coming in. We're going to be talking about the Adelson case. If y'all have any questions about the Adelson case, please put them in the Discord in instant message in member chat or message me if you have any. The motion for dismissal for extreme government misconduct will be, I think, help me, Patty. Is that going to be Monday or Tuesday with the Karen Reed? I believe they've got so many motions still out there. It's hard for me to keep up. And be in prayer for my interpreter. She got ASL interpreter. She got bronchitis around the 17th of November and has been violently ill with it. And it finally disappeared a couple of weeks ago, and it's back. And I just feel for her. But what we're going to be doing, and anybody, let me say this: I'm asking for special mods just for the Karen Reed trial. If you want to stay on after that, we can discuss it. But I need mods for the Karen Reed trial because I need to be interpreting as much as possible. I need one mod, and I think I'm going to talk to Yana, who can. We have Haley Mouse and one other. I need one other to be able to come in the back office in StreamYard and be able to run things, pop things up and down. Be able to be comfortable enough with StreamYard. If you know how to do StreamYard already, this might be for you. Be able to take away banners, add banners, pop up comments, take away comments, things like that. Pop up the names of who's testifying and who they're with. And also I need a couple mods for that in YouTube. I need a master mod in YouTube because I need to be interpreting as much as possible because I know we're going to have at least 3, if not 4 deaf people wanting to watch this trial, and I can't do anything if my hands are interpreting. Then in the afternoon, when possible, which will be most afternoons, my interpreter will be able to come back on because she is gainfully employed. Thank you, Jesus. Last year she was not. Because of COVID, things switched. So please reach out to me in Discord and say interested in being a mod. We have a full set of mods for the channel already, but a lot of the mods cannot or not feel comfortable doing the techie stuff. So I need techie mods. And I got to be honest, Haley Mouse can vouch for you if she's here. This StreamYard is stupidly simple. I can do it, you can do it. And I'm calling me stupid, not you, but me. And so for that, I am needing people. We got to get it lined up by the end of the month. So I need time for y'all to practice with me while we're live on other lives. This, I hope, is going to be a trial that will help our channel grow. I know a lot of people are kind of waiting for this trial. So I'm happy that I have deaf people who are wanting to watch this trial. So it's very important to me to make this accessible to everybody. I like having the decorated background, but I'm trying to get used to not having it, because in the Karen Read trial, when interpreting, I will be back here like this, and the background is a necessity. Yes, it is a necessity. So it's very important. With all that, tomorrow, 7 o'clock, we're going to have the Donna Adelson. If you have any kind of questions, comments that you want us to talk about and answer, please go to our Discord. Please leave questions in the Discord. You can go to the member chat. Oh, wait, I got unreads. Let me go see where's that member chat. Oh, cool. Angela sent us something. I already saw that, didn't I? Yes. And for those of you who just hopped on, are you ready for this? Special Prosecutor Hank Brennan could make $225,000 just for trying Karen Read. He was guaranteed $75,000 for his work trying Karen Read, but but there's a public records request filed by WBZ revealed that Brennan pay has increased to $225,000 from $75,000 to $225,000. To me is, what the hell? I mean, come on now. They will have spent more than $500,000 just with the prosecution. This is with the just the fees for the DA, assistant DAs. I said this and was told I'm not an attorney, so I don't know what I'm talking about. Here's an attorney who knows what he's talking about. What is he talking about? And never provided, right? Let me see. What is he reading? Let me pull this up, guys. This is something that we may want to get into this afternoon before I leave. Give me a split second. Anyway, I got to pull this up. I don't know what's going on, but something just came in and I'm going to see if I can figure that out. Give me a momento, please. Momento, please. Momento, please. It's from Lawyer You Know, but Church Brandy said something about it, and I'm going to go to him right now. I don't know if I. Let me see. Dismiss extraordinary misconduct. Okay. We've already looked at this. So let's give a recap. This whole petition for defendant's motion to dismiss for extraordinary governmental misconduct is because they have altered, destroyed, or have hidden evidence. So one of the things, and no, we've already talked about this. We're good. Nothing new. I thought there was, but nothing new. Butt dialed. Yeah, that ain't even haven't been talked about. Butt dialed. One of the things that irritates me so much with this trial is the blame game. It doesn't matter if Brennan is now the ADA. It didn't matter if it was Lolly. He is representing the office that screwed this up. Therefore, he and they will have to bite the bullet. If you're going, maybe he went back to them and said, guys, this is so screwed up. I'm going to walk out, or if you don't pay me more. And I bet that's what happened. And now he goes from 75,000 225,000. That's $150,000 difference if my math is correct, which it may not be. But again, where's the butt dial? No one's really talked much about the butt dials, have they? That to me is really just totally BS. So anyway, I am going to, I'm looking in my Discord and seeing, I'm just doing double checks before we hang up because I don't want to get us hung up and then all of a sudden we have something that's happened and I had to come back live again. On Saturdays, it's easier to do. But right now, please, if you guys know, I'm not kidding. If you are really wanting to be a part of my my mods and can help me in this, especially with this trial. I know it's a long trial and it's a lot to commit to, but if you are interested in committing only to this trial, I am more than happy to accept your help. One thing I want to say right now, I need to say this while I have y'all on here, and I've been waiting to say this, and I don't want it to come across pissy and mean, but there's enough of you out there, and I'm going to say this right now. I love a lot of these other content creators. I thoroughly enjoy Brandy Churchwell, Emily D. Baker, Broken Baker, love you, RA, love you, all of these people. But I am going to say something, and it may rub people wrong, and if you leave, forgive me for it, but this is my channel. Every time people bring up these names in comments that they're live and they're doing something while we are live, my viewership drops dramatically. And right now I only have 10 people watching live. I don't have the thousands of people. I'm too small. I'm new. And when you bring up other people in your comments and what they are doing right now, you hurt me. If you have something like, hey, RA is going to have a special guest next week, you might want to watch it, put it in my Discord, message me. And then if at the end of my live, I will bring that in as an announcement to support him. I will bend over backwards for that man. He's helped me so much. And Brandy, I mean, they helped me get my first 1,000. I will do anything I can to support them. But when you guys bring up other commentators during my live in the comments, you hurt me. And I know you don't mean to do that. Even when you say, oh, by the way, Brandy said this, or by the way, RA is saying this, the moment you drop another content creator's name in my live, people leave. I have watched it. I have been real quiet about it because I didn't want people to think I'm being pissy, number one, and I was making sure my numbers were dropping, and it hurts me. So I support them. I love them. I boost them. I share them. I watch them. I go on every single day to 7 content creators, even when I'm live, and hit that like button just to help them in their algorithm. I'll comment, hey guys, good to see y'all. I do that while I'm live with you guys because I want to help boost other people. This world is big enough for all of us. But when you bring up another content creator in a comment, I'm going to delete them. I am not trying to be mean. Really, I'm not. And it's not about me hating them. It's all about being fair to me. And I got to protect me and my channel. And if you do have something, and I'm reiterating it, if you have something that they're going to do that's special, it came up yesterday. I waited for a long time and then I deleted the comment, but I would love to shout out people who are having something unique and special. If they're doing like Ian does his fundraising, hell yeah, I'm going to sit there and boost him, but I'm going to do it at the end of the live. I hope y'all understand. I hope y'all don't get mad. I will reiterate this again. If you see that you have brought up a content creator and the comment is no longer there, don't take it personally. I'm just training you on where to put the comment so I can bring it up in a place and time that benefits me and them. Okay. I have lost a lot of content creators by almost 80% sometimes and never gained them back during the live. And that is a tough place for me to be. But there are times that I will really highly boost them. So if I know, and we haven't done any, we also do, okay, now I'm really Patty. Now I'm really going crazy. Pro have Beecher, Pro have Beecher, isn't it? Pro Hawk Vice, Pro Hawk Vice, Pro Hawk Vice. I said it right, but I don't know what that is. But we do Pro Hawk Vici, Pro Hack Vici, Pro Hack Vici, Pro Hack Vici. Okay, I'm just gonna say Pro Hack and leave it. Uh, but I guess what I'm saying is if there's somebody on right now, for example, and we do raids, and I support people. I go over there and give super chats to them. Grandma's house, alternate juror. I go over to all of them. I do have memberships to some of them. So please understand, I am supporting them financially and with viewership. Oh, you're behind. Started late. No, that's great. But now it's Prohawk Vici. Vohawk Vici. Okay, I'm just gonna say Vohawk and leave it. My dyslexia is driving me crazy. But please, so I appreciate everybody. Now, if you are joining right now and you have not hit the like button, let me refresh because I want to see if you have not hit the like button. We have 20 thumbs up, but I don't have 20 of you in here. I only have 8. So if you have hit and you are still listening, the like button on my live, please comment ILIKED before I do the drawing in just a minute, because this is going to get you into the birthday month giveaway, and it's going to be big because it's my birthday month. And any and all, and it would be great to have a record breaking. Oh, that's another thing. I was going to say it'd be great to have a record breaking month in my super chats, because honestly, I don't really get them awesome. Yesterday was, I think, the best day. The other time I ever did that many, other than yesterday, was when people donated for my sister's funeral. We are still in the hole on that. So, but your donations were greatly appreciated, and we love you for it. But y'all put I liked in here right now because I'm getting ready to draw. And 8 out of 20 of you, come on. 8 out of 20 of you. What are the analytics on this? Let me see the analytics. Yes, I love having all these monitors. Let me show some of y'all who've not seen. Concern likes revenue 19. By the way, I want to thank you for the super chats. We've only had 78 views. We've not had a whole lot of views today. But I want to thank everybody for the super chats right now. Patty, thank you so much. You have really blessed me greatly. You have helped me pay for the internet for today. And Jesse, thank you for your gifted membership. You too have also helped to pay for the internet today. So thank you so very much. And I love all of you. By the way, Kitty Kitty has been found. My Kitty Kitty went missing. We thought she escaped. We thought we were going to have a problem, but thank God she was hiding in a place. I don't think she's feeling well. I think she's got a urinary tract infection. So that's what I'm going to go deal with in a minute. I'm going to go pick up her medication. So once again, thank you so much. We still only have 8 liked. I'm going to go ahead and share stream, and let's get ready for the giveaway. Get ready for the giveaway. I wish I could get rid of this view. I hate this one, but it's not even listed. Where do I want to go? I want to go here. Okay, let me get me back here. Oh, no one's going to tell me to shut up. No. Oh, you're welcome, Chris. You're welcome, Chris. But understand that tomorrow night, I hope we'll have fun. Please, guys, I need as many of y'all to show up. We need big numbers for tomorrow night. I know a lot of people are busy. I'm having Tanika on. I would love to have a great showing. The Adelson trial is actually starting in to be a very juicier trial. I don't know as much about the Adelson trial. Like, she didn't know a lot about the Karen Reed trial. So we're kind of doing a thing. And today at some point, I'm going to post that video I did with her. Tomorrow at 7 p.m., I am going to preload these shows so you will see it. So tonight you will see it. It'll be there. 7 p.m. Central Standard Time. Also, I will be putting up the video. She gave me permission to release it. So I'm going to put up a pre-recorded video of her and I discussing the Karen Reed. She is a love. I love her energy. I love what she stands for. She's a wonderful person, and I love having her on my show. Okay, let's do the drawing. Yippee! Okay, Patty Love, I got a screenshot. You are in for the end of the month's drawing. Oh, snap. Guys, I'm going to have to come back and do the drawing for the February tomorrow. Do you know why? I think I have to preload the wheel. And I've got a lot to do, so I got to preload the wheel. Now, the way this program works is that each name will be listed, but the weighted will be different. So your name, if you've done something 100 times, will be listed once, but in the algorithm of this program, it will, if you've got 100 votes, 100 slots, and it will it goes for that. But we will do the drawing tomorrow. Maybe we'll do it with Miss Tanika. I think that would be fun to do it with her tomorrow. So I'll set everything up. I'll have it up and running. So we'll do it tomorrow night at 7 p.m. Good luck to everybody. And thank you so very much for loving me. Thank you so much for the growth, the support. I mean this with all of my heart. Thank you so much for your support. Heidi, the Highlander, and I'm brain cramping on the man. I'm tired. The Highland Cow is my new mascot. Also, for those of you who are Catholic, our hearts and prayers are with the Pope Francis and his recovery. If his recovery is not what the Lord intends, and he is going to be going over and transitioning into the Lord's hands, we pray that it's peaceful and swift. And all of our prayers are out there for all the Catholics in the world who are mourning his health condition. It's a very precarious time right now, and we get it. Oh, thank you, SHB1. Thank you so much. You just missed it. I will add you in tomorrow's. I'll give you an extra entry. Please come back tomorrow. You literally just missed it. Come back tomorrow. And if you are a rewatcher and you hit I liked, I catch those. So if you're rewatching this, if you are a replay crew, go ahead and put I liked in the comments. It does catch. Okay. Thank you, June. Thank you, everybody. I love and appreciate you. Y'all have a fabulous rest of your Saturday, and I'll see you tomorrow night. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.